wherever you would like. Yeah, you can feel like a legislator now. So so it's 1 o'clock and we like to, as you know, the legislature likes to run a tight ship around here. And so we'll get started. I wanted to say a few words and some housekeeping, and then allow my colleague, the chair lady, Angela Cockerham, to say a few words. So just to start off, I want to say thank you to everybody here for participating and being part of this. And it is a function of our government, particularly the legislative branch, to have input from members of the community, obviously in the state. And so we couldn't do our job without y'all's participation. And so I appreciate it and just wanted to get this kicked off with those words. I'm going to first, just so we kind of know who everybody is, go down the list and call the roll. And then we may just have each person introduce themselves. We have, I think, 5 people on Zoom. And before I do that, I want to introduce the folks here, so who have helped us get here and will be our eyes and ears, if you will. Over here, I have Pat, who is my assistant, or the Senate assistant, and she is who's been sending out the information. And she can help in any way possible on this. We have Gwinnetta from the House Counsel's office, and we have Ethan here from the Senate Counsel office. They are the attorneys for the House and the Senate respectively, and they will be helping us. And also in the legislation that we're going to go over in a minute, we have the Judicial College has been tasked to help us as we need it. And I think I see Randy Pierce on the Zoom. Is he here? There he is. Okay, so appreciate him being with us. And then we are live streaming the task force meeting. So you can go on YouTube and get this, and just know that we are doing live. And about the mass, you can certainly, there's no requirement that I know of, but I'm going to have mine off while we're presiding or while we're handling this. And I think since there is enough space in here, you can take your mask off if you would prefer that, or you can leave it on. So with that, I'm going to first go down the list. So we have Representative Cockerham here. Justice Griffiths, Chancellor Troy Odom, Chancellor Jennifer Schloegel. She's on her way. Okay. Judge David McCarty is here. Mark Chin, Donna Smith. Are they able to hear me on Zoom? Okay. Let's see. Okay. Reggie Blackledge, I think he said he was in court today, or is he on here? Okay. Melissa DeFada. If you're on Zoom, I should say this. If you're on Zoom and I've called your name, if you can, are they muted? I'm talking to my technology folks.
This is Melissa DeFada. I'm on the call.
Okay, Melissa's here. Okay, thank you. Leanne Turner. Deandra Hosey.
I'm here. I'm on Zoom, Leanne.
Hey, Deandra, thank you. Michael McCauley. Michael was on. Okay, Michael's with DHS. Professor Debbie Bell.
I'm here.
What would a task force on child support and all be without Debbie Bell? and Professor Shirley Kennedy. Thank you. So with that, I just wanted to say, and then I'm going to turn it over to Angela, how we got here and why we got here, honestly, is a function of what I personally, both as a senator and as chairman of Judiciary A, have heard. I think Angela will concur that about what we have heard as legislators about our, and I'm generalizing here, our system of awarding child support, but also about how things are operating in this area of the law. The short of it is that we've heard complaints, and at the start of the legislative session this past year, where's Brittany? There she is. I forgot to introduce Brittany Davis, is counsel in the Lieutenant Governor's office. Asked Brittany to do some research. And what we found was that, in short, Mississippi is in the minority of how we handle different things in this area. Since the task force or this bill was put forward, heard from many in the legal community, both in the judiciary and the lawyers, about how they were glad to see this was happening, because I think that they've heard probably the issues certainly that we've seen. And myself, I'm a practicing attorney in this area. I think Angela is as well. And it was my belief, along with the leadership in the Senate, and I believe the House, to have this task force so we can address these issues. And we're going to go over the bill itself. You have an agenda in front of you. And we will be calling on a chairperson and a secretary. So please be thinking about that before we get to it. But this is something that is going to be beneficial, we believe, for the citizens of Mississippi, because as I've come to realize that as maybe judges and attorneys, we're in the courtroom and we handle these issues and deal with these every single day. But the average person, that's not something they do. This is their first and sometimes only experience with the court. And when I say the court, in the courtroom and the law, and also I'm generalizing again, but the laws that are in place have not been updated. And actually, there's some in the law that says we need to be updating them on a more frequent basis. So that's all the reasons how we got here. And so with the research that Brittany did, that the Lieutenant Governor's office did, we prepared this and put forward this task force, and appreciate everybody being here. And at the end, it will be recommendations that we will take back in January. And if hopefully we can put forward those in the legislature and either get those into law and certainly have a debate on them on that. Our recommendations are due December 1st. So that's kind of the schedule that we're going over. So with that, I'm going to be quiet and turn it over to Angela.
Well, I just want to first start off by saying how extremely excited I am about this particular task force. And I think that we have a very well-respected and talented group from the judiciary as well as practitioners that comprise this task force. When the legislative session first started in January, I had a bill in Judiciary A that would revise child support guidelines that had been introduced on the House side. And when Bryce and I met at the beginning of the session, he said that he wanted to possibly look at a comprehensive bill with respect to a task force that may look at possibly calculating child support guidelines in addition to some other matters that are respective to the Chancery Court, such as guardian ad litem issues and no-fault divorces. And quite honestly, I think with respect to the House and the Senate, we both get a voluminous amount of bills with respect to child support calculations, looking at how can we possibly revise those, how can we enhance those, what do we do about no-fault divorces, and how do we make those laws better? And I have introduced bills to look at revising those. Quite honestly, I think a number of my colleagues do, just because some of us are practicing attorneys, yes, but also we're getting feedback from our constituency. And I think by you being on the bench, and also for those who are practicing, who are on the task force, you're hearing directly from your clients. You're smelling it, you're touching it, you're tasting it every single day. You're waking up with it. And we want that feedback. That's what we need in order to make these laws better. I am, somewhat guilty of it. I'll say, oh, when I'm lying asleep in my bed at night, or I'm driving up here to the Capitol, oh, this is going to be such a great law, right? And then in practice, when we actually see it in the code, and the judiciary has to actually interpret it, or when you as a practitioner, you're actually deal with it, I actually hear back from a lot of my colleagues who are saying, what were y'all thinking when you enacted that particular bill? And
That's
so,
never been said in the judiciary about the legislature.
but I think one of the goals with this particular task force is to make sure that we actually get, number one, really good feedback, again, which is why I said at the outset of my remarks that I'm so thrilled about this particular task force. But because child support and divorce affect so many people, this isn't just one isolated cause that doesn't affect, or it just affects a particular segment. There's not one person in this room that you can't say, well, I don't know someone who has gone through a divorce, or I don't know someone who is paying child support. I mean, I think all of us in this room can say that we know someone, or if we haven't gone through it personally, we know someone that this affects personally. And so I'm hoping when we leave that we'll have some good recommendations, and I know that we will, just with all the talent and the skill that we have on this task force, that we can bring back as a set of recommendations. And to those who are participating in Zoom, and again, to all of those who are in this room, I thank you for taking the time to serve on this task force. I know that you could be doing a million things, but I appreciate your effort and your service and your willingness to serve. Thank you.
Thank you, Angela. And Angela and I have had a really good working relationship, and I think we have accomplished a number of things this year. And I agree with her. When I've been in the Judiciary A chairmanship for a year, and gosh, probably a third of the bills were dealing with child support of some kind or some way like that. And so, to her point about we see a lot of them, and what that tells us is that in our case, the senators, in her case, the House members, are hearing from their constituents about these issues. So that's why we thought it was the right time to bring this forward and to do that. So I wanted to do a couple housekeeping things, and then you have your agenda right here before you. And what you also have is your packet, which we'll go over that in a minute, just to kind of give you an idea of kind of the structure. We had booked out today, this afternoon, and tomorrow. However, I think we could probably, with how things are, and Angela and I talked about this, could actually get things done today, and then we can set another time to come back at a later date and let the task force kind of see what we've got and think about it. I do think we need to meet certainly at least one, maybe two more times before the recommendations go in. And under the bill that established the task force, December 1st is the deadline to have the recommendations to the legislature. And so with everybody's schedule, like Angela said, everybody's busy. We want to be mindful of everybody's time. Speaking of that, also, I think Pat may give you out, for those who are not in the agencies or government agencies, under the law, you are entitled to travel reimbursement. However, there was a oversight on the appropriation side. What I would ask is that you fill out a voucher, and we're going to work to make sure the appropriation gets through and we can find for reimbursement on that. So before we head into it, and I know I called out everybody's name, but I would like if we could go around the room and just state your title and where you're from, because we did do this task force with certainly different parts of the state in mind and different ones from the judiciary system in mind. So I'll just do it this way. We'll go around we'll start at the end of the table and go around, and then we'll go to the folks on Zoom. Hey, Troy, I'm sorry, that microphone, if you could, because we are streaming this, and that would help people to hear that. And you push the button yeah, there you go. Did it turn green? There you go.
Troy Odom, one of the 3 Chancery judges from the 20th Chancery District, comprised of Rankin County, one of 2 Chancery judges sitting on this legislative task force. And I just wanted to tell y'all, Chairman, that Judge Jennifer Schlegel from the coast is going to be joining us in person and is on her way, just running a little bit late.
Great.
I'm actually here on Zoom too.
Oh, okay.
Good deal.
Hi, I'm Shirley Kennedy. I'm the Director of Family and Children's Law at Mississippi College School of Law.
Good place to study law.
I think so. I'm a graduate there myself.
Thank you.
I can do it. My name is Kenny Griffiths. I'm a justice on the Mississippi Supreme Court. I'm for the Central District. I'm from Ridgeland.
And I'm Senator Bryce Wiggins, Chairman of Judiciary A, and my district is Senate District 52, South Jackson County. In addition to doing this, I also have my law firm, Taggart, Rhymes and Wiggins, and do general practice, including family law and youth court and matters like that.
I'm Angela Cockerham. I chair Judiciary A in the House, and my legislative district encompasses Emmett, Wilkinson, Pike, and Adams. I practice in Southwest Mississippi. My law practice is Angela Cockerham, PLLC. I practice a great bit in Chancery. I also have a municipal practice. I do public finance. I adjunct law professor at MC Law, where I teach Louisiana civil procedure and Louisiana mineral law. And I also practice mineral law as well.
And she finds time to sleep somewhere in there.
I'm Daniel Galarno. I'm the legislative liaison for the Department of Human Services.
Danny.
I'm David McCarty. I'm from the Court of Appeals. I live here in Jackson, and I'm District 4 of the Court of Appeals, 1 to 10 judges, but I represent Hinds County all the way down through Southwest Mississippi, including Representative Cockerham's districts, all the way east to Jones County. At the Court of Appeals, we do a really heavy number of domestic decisions, so I'm thankful for both Senator Wiggins and Representative Cockerham and Justice Griffiths for bringing me over here today.
Good afternoon. I'm Mark Chin. I practice family law here in Jackson, Mississippi. I'm one of 2 experienced family law attorneys appointed by the Board of Bar Commissioners.
Okay, if we'll go to Zoom, and I can't see from there, but we'll start with Judge Schlegel.
All right. Hi, I'm Jennifer Schlegel for Chancellor in Harrison, Hancock, and Stone County. I was elected in 2010 and have served there ever since. So I am in the car very close to the Capitol now.
Thank you, Judge. Next, just feel free to chime in if you're on Zoom. I'll tell you what, I'll do it this way. I have Michael McCauley.
Hi, I was appointed by the Executive Director of the Mississippi Department of Human Services, Bob Anderson. I work in child support enforcement. I've been with the agency about 10 years.
Thanks, Michael. Deandra Hosey.
Good afternoon. I'm Deandra Hosey. My law practice is the law office of Deandra Hosey. I handle Social Security disability cases statewide, and I handle chancery court matters here in Hinds County.
Thank you. Leanne Turner.
Hi, I'm Leanne Turner. I'm in Starkville, Mississippi. I'm an attorney in private practice, and I also do some youth court referee work as well as special master in commitments. I was appointed to the committee based on guardian ad litem work. I've been a guardian ad litem in this state probably 13 or 14 years now, and my whole 25 years of practice have been in chancery court.
Melissa DeFada. I thought she was on there. Okay, maybe not. Randy Pierce.
Good afternoon, Mr. Chairman, Madam Chair. I, on behalf of the Judicial College, Carol Murphy and I are on the phone, on the Zoom with you. Carol's mic doesn't work today, so I'm speaking for both of us. Carol prepares the published handbook for chancery judges that is on our website, and she and I, on behalf of the Judicial College, of course, will be here and available to assist this valuable study committee.
Thank you. Do I see Melissa up there?
I'm here.
Okay.
Hey, sorry about that. Hey, I'm Melissa DeFada. I'm a sole practitioner down in Jackson County. I do mostly family law. I do some guardian ad litem work, and most recently I've been doing some mental health work as well. And I'm just happy to be part of this group.
Well, great. Thank you, everybody. And so before I go ahead.
Mr. Chairman, this is Randy Pierce. One thing I do want to add, if you could ask Pat, Carol Murphy or one of us will drop the Judicial College's email in the chat. So if y'all could add us to the email, we'd appreciate that. And I appreciate Judge Schloegel for sending me the link today. But thank you, Mr. Chairman.
Thank you. And we have Professor Bell. Professor Bell. Was she on?
Debbie Bell. Hi,
Okay.
Debbie Bell from Oxford. I teach family law at the University of Mississippi School of Law, and I'm very happy to be a part of this, excited about it.
Thank you very much. Before we jump into kind of the task force itself and organizing and going forward, does anybody have any questions just about where we're headed and what we're doing and any just kind of the logistics or anything like that? Hearing none, that's great. So I hope somebody's been thinking about who would like to be chairman. Let me say this, and Angela and I have talked about this. We do need to, pursuant to the legislation, we need to elect a chairman and a secretary. And we don't see this as being, everybody in here is busy. It's about just being the chairman and then the secretary to kind of gather the information that we're doing. You have the staff, both Pat up here, the legal staff in the Lieutenant Governor's office in here, as well as the Judicial College to help out on all that. So, and I personally am not going to consider myself in the role for chairmanship because both Angela and I do think that it would probably be better if somebody from the committee was served in that role. So, did you have anything you wanted to say on that?
It's just that I do agree. I do think that it would be better if someone from the committee would serve as chairman and secretary.
So what I'm going to do is open it up at this time to nominations for the role of chairman pursuant to the legislation. And what we do in the Jackson County bars, if you don't volunteer, then we volunteer for you. So, and look, don't be shy. If you think you'd like to, please say so, and we would consider that. Okay. We have a second.
I appreciate the nomination, Justice. However, I have a paternity case tomorrow morning. If Chairman Wiggins can guarantee that we will get our work done today, I would be more than happy to do it.
I will guarantee that we won't. Yeah, at this time, I see no reason why we need to be here tomorrow, because I think a lot of the things can be done when we go back in gathering the information and by email and sending that in. And so that when we come back the next time, we can gather and talk about that. So yes, I don't think we will be here tomorrow. I will guarantee it.
I'm happy to serve in whatever capacity.
Thank you. So that's we have any other nominations? Nominations closed. All in favor, say aye. Aye. All opposed? Congratulations. We have our chairman.
Thank you.
Now we need the secretary. Any nominations for the secretary? Thank you, Justice. Judge McCarty is nominated. Do I have a second? Have a second? Okay, any other nominations? Nominations closed. All in favor, say aye. Aye. All opposed? Thank you, Judge. Appreciate that. So again, before Pat and the Ethan and Gwinnetta, they'll give you all the information, and so that we can be in contact through all of that and do that. So with that, then if Mr. Chairman, if it's okay, I don't mind taking us through the agenda.
Mr. Chair, can you hear me now?
Yes.
I've been trying to say something for the last 15 minutes. Apparently my mic was not working. I'm Donna Smith. I'm the only mask person in the room because I'm in circuit court today, and we have a countywide mask mandate. And of course, this is the Chief Justice's COVID protocols. So I just wanted to let you guys know I'm not an interloper on your meeting.
Thank you very much. Thank you, Mr. Chairman.
Take us through, Chairman. You have a lot more experience in sitting on task force than I do, so I will follow your lead.
So, and let me say this, I think that this task force is really how we wanted to go. Angela and I, our part was setting it out in the bill and ushering it through the legislature. And so that's why if you skip over to in your packet, if you skip over to the tan page and go to where Senate Bill 2621, we'll go through that. So this task force is really how we want it to happen, in the discussion, how we want it to occur. And it's not lost on me that particularly with the judges that through the issues that are brought up in the bill, that we all may have a difference of either opinions or things that we need to that we've heard. And so we need to discuss those and have if we need to, a robust discussion. So first, if you'll go to your packet, Senate Bill 2621, that's the enacting legislation that the legislature went through and passed. And the first part of it is just the appointments that went on. If you go down to line 46 that would be page 3, and then skipping down, those are going to be the items that we are tasked with looking at. And just to kind of go through them real quick, on line 50, review the models used by states to determine the base child support amount due, including income shares model, percentage of income model, and the Melson formula. And actually, I'll come back to that and mention that. The next one is on line 55, review the special provisions for childcare expenses and formulas for shared custody, split custody. Then the third one on line 59, review the current trends of law regarding no-fault divorce and make recommendations based on the review. Line 62, review the current trends in the imposition and cost of fees for guardian ad litems. I will tell you in particular that issue for a number of years has come before the legislature about issues for guardian ad litems and the fees. In fact, I mean, most of these have for the number of years, but that one seems fairly specific, and that's because that's been coming up before us. And then line 65, review Senate Bill 2220. What that bill is deals with special needs. And there was debate in the legislature this past year about child support terminating when a special needs child reached the age of 21. And there was discussion that should continue. So you have that in there. And then this is our good old catch-all, line 67, review other matters related to the above issues or related to domestic law. And then if you look at your items, if you go over to the next, I guess, item in your packet, what you have is you have the three child support guidelines or models that are used in other states. And I will just kind of hit some of the highlights for you. So if you look at the next page over, you have the what's called the percentage of income model. And if you look at the top there, 9 states and the District of Columbia use the percentage of income model. This is not, this is what Mississippi uses. So Mississippi is one of only 10 states to use this type of, I guess, calculation. And you can see there, it says the model sets child support at a percentage of the non-custodial parent's income. If you go over 2 pages, you then have what's called the income shares model, where 38 states, along with Guam and the Virgin Islands, use this model. So apparently this is the majority one that gets used, and a total support is calculated based on a set percentage of the combined income of both parents. Then the non-custodial parent share of the amount is calculated based on a proportion of that parent's income. We can get into the specifics of that, but that's essentially what that one does. And then the third one, if you flip over, let's see, about 4 pages, the Melson formula, which is used in Delaware, Hawaii, and West Virginia. And the 3 basic principles of the Melson formula are parents may keep sufficient income for their basic needs to facilitate continued employment. Parents shouldn't be allowed to keep more income than required. And let's see, and if income is sufficient to cover the basic needs and all dependents, then children are entitled to benefit from the absent parents' higher income. So, and then those are the 3 models and the information at your disposal to look at as we go forward and to discuss. Then the other items in your packet are actually there's a you can see if you need each state is listed and the model that they use, and it gives you the statute that is there. And so you can see and if where they are and can, if you need that pulled and looked at, we can do that as well. Excuse me.
Mr. Chairman?
Yes,
This is Melissa DeFada. Was this packet emailed previously? I don't have a copy of it.
Okay. It was
Neither do I, Mr. Chair.
Okay, I'm sorry. I thought it was not emailed out. What we will do is email that as soon as this is over with. I apologize for that. I thought it had been, but the packet, we will email that out to everybody so that you have that as well.
Thank you.
Then if you go next in our packet is the Senate bill that we talked about that's in our designation, Senate Bill 2220. And if you look at that, and I will state that I personally have not had any dealings with it, but apparently this is an issue throughout the state, is about the special needs and child support. I was looking for the optimum. Thank you, 148. If you look at line number 148, that is the language that was being proposed. And understand this, that just like Angela said, there were a number of bills that were coming through, and we wanted to do this task force. So this did not become law, but we wanted the task force to look at it to make the decision. And the bottom line of what the bill that was being proposed, and by the way, this came out of DeSoto County, was that if on a special needs child that upon reaching 21, the non-custodial parent couldn't automatically stop payment of child support. That's the bottom line. And then on your materials, what you have is you have a list of and by the way, all these will be emailed out, a list of the states in the southeastern states and how they handle no-fault divorce and what they say and how they specifically address it. My personal take on it after reviewing this is we've consistently heard that Mississippi was the only one to no longer have a no-fault divorce when actually, if you look at a number of southeastern states, some of them don't have a true no-fault divorce, but they have a version of it. So particularly like Alabama. So these are ideas, and we're tasked with looking at that. So with that, that's your materials, and of what we need to look at and how we need to do it. And I think our intent, both Angela and mine, that we get input from from the members of how y'all see that. Also, if anybody feels like we should bring somebody here and hear from them, we can do that too. But that falls under your guidance, Mr. Chairman. So with that, that's really an introduction to the materials and what we have before us.
Any reason to delay diving into them?
I don't think so. No.
All right. Let me tell you this. I think of the topics that have been listed in the Senate bill for the formation of the legislative task force, the one that had the most consensus from my, informal survey among chancellors and practitioners was the no-fault divorce statute. That may be an easy one to dive into first before we get to the more complicated and involved child support, to sort of a icebreaker. What is the general consensus with the legislature? Is it even able to pass a statute akin to a no-fault?
Yeah. Should I'll give my impression, and I think that's a totally legitimate question. And I was going to say, because part of this is to give guidance to the legislature, and so y'all need to know where we are. My take, if you recall, a couple years ago, the legislature adopted what is now known as the spousal ground for divorce, abuse. The year before that, the legislature had actually put forward a no-fault divorce ground, if I'm not mistaken. And it died on the last day of the legislature. And it died in the Senate, if I'm not mistaken. So then we came back, the legislature did, and put forward the spousal abuse as part of the cruel and inhuman treatment. I think, and I'm speaking for the Senate because I think that's where we are. Angela, I'll let her speak on the House. I think that of your lawyer, legislators, senators, everybody is supportive of it. And because they have seen how it one, how it gets used. Number two, where we stand in relation to other states. There are political concerns about it, that if we do a no-fault divorce, the reality is that somehow is seen as not supporting marriage. And that is why I think a few years ago that it didn't make it through the legislature. It has always been, I guess, the politics of it. And so it sounds like if that was if that's the number one thing that rose to the level, is what I've heard, which is within the legal community and the judicial community, that the no-fault divorce is pretty much accept or thinks it should be done. I will note that Judge Schloegel is on here and on this task force, and I forget the name of the opinion, and I think we have it, Brittany, but when we did our research, her opinion was very instrumental in getting us to this point because I think that opinion's been accepted as well written as to the issues in Mississippi on no-fault divorce. So I'm speaking from the Senate side. I'll let Angela speak to the House side.
Well, and just in talking to some Judiciary A committee members, there has been quite a bit of support in terms of why don't we have a bill. I can say, in talking to my counsel who's sitting here, Gwinnetta Tatum, and I get quite a bit of Judiciary A bills, as Bryce does. And so there are quite a few introductions for that particular bill, for that particular piece of legislation. And I think Bryce gave a pretty good historical context in terms of the movement that has transpired thus far up to this particular point in that particular vein. Typically, it has been seen sometimes by some that maybe, and I'm not talking about in the legislature, I mean just the overall sentiment across the state, that maybe that's a move to say that maybe the Mississippi is not in support of marriage. However, I think on the House side, in terms of the members that I have spoken to on Judd A, some of them, especially, I can remember, quite honestly, a very vivid conversation with one member in particular who wanted to attach an amendment to a bill that we had this particular session. But I knew that we were going to have this task force, and whatever we put forward, we wanted it to be very well vetted. Not to say that the amendment would not be, but just that we wanted something that would be studied, that we could bring forward to the committee, that had some input from practitioners and judiciary alike. I don't think that, especially around the Capitol, if you're waiting for everyone to get on board for something, you'll be waiting for a very long time. I think that if this is something that we want to do, then, just like you said a few minutes ago, Judge Odom, that if out of all the topics that we brought forth that Bryce just mentioned a few minutes ago, if we want to take a look at this one, that we get to work on it and just see what happens. As I think everyone who's on Zoom and who's in the room can tell you, sometimes we pass something and we think, oh, this would have taken a very long time. And then sometimes some issue takes a very long time that you think would have probably happened in one session. But definitely, if we don't put it forward, we'll never know.
Senator.
Yeah.
Could I make an inquiry? I kind of going back to the question you asked earlier that nobody responded to. Exactly how do you anticipate the work of this commission being done? Because what I see is at least three categories of matters, one being child support, another being guardianships, and the other being just general domestic laws with grounds of divorce and things like that in it. And we've got some mighty firepower in the legal world with Professor Bell and Professor Kennedy here. And it seems to me that it would be good for us to organize our work maybe amongst those subject matters and let our law professors guide us in the ways in some part of it it seems to me where I might know a lot more about one part, say domestic laws, I know less about guardianships. But to see if we can organize as we go from here, because I'm not sure with only one other meeting, it seems like we're going to do all of our work either by Zoom, by email, or by smaller subcommittee type meetings and things like that. And those are just the three topics that come to my mind to begin with, is how to divide our work.
Yeah, Mr.
I don't know the answer to that, but I'll tell you, we don't have much time if we're going to be doing anything at all with the task force. And you're absolutely right. This task force has a ton of firepower, people that have been in this business for a heck of a long time and that are very respected. So I don't know the answer to that other than to dive in as best we can today and assess where we are to see what we need to do, if we can even have something ready for December 1.
I'm sorry, there's nothing in the legislation that sets out how to do that. It's left up to the task force. Having been on something similar before, a lot of it can be done, to your point, with the firepower that you have outside, and then submit it by email, or the suggestions. The staff can put that together. When we get back together, then we hash those things out. And it may need to be more than two. I was just kind of using that depending on people's time. It sounds to me like everybody's really into it. And so we could meet, every 3 weeks or something, if that's what we so desire. All that we're required to do is have recommendations to the legislature by December.
I just brought that up because I think if we organize our work in different groups and categories, and we start with the laws that we have now, and we focus with the laws as they should be, maybe, and have that discussion. But it seems to me that a lot of this, from my perspective, should be driven by our chancellors and should be driven by our law professors more so, and our practitioners. To have a say, but while some may have an interest in child support, I think the DHS version of this is we want to know about child support, and we want to have a discussion in child support, but maybe not as much of a discussion in the guardianship part of it, or other areas. And I mean, that can kind of naturally fall. I raise that as a way to where do we get kicked off? Do we complain about the one we hate the most, or do we start with the ones we like? So,
Mr. Chairman, but I would just say, from our standpoint, organizing it into the groups is a smart way to go about doing it. You mentioned the 3 child support, GAS, grounds for divorce. I mean, that seems very good. I'll just go and many of y'all are familiar with the criminal justice reform. That was done that way. You had different committees that addressed those issues, and then you came back together and they put in their full report of that. So, and it certainly, I don't think we can get to it all today, but that's why I think we can go back and use the people that we have.
I think that's a great idea, to make sure that we dividing the brain power that we have on the task force into those divisions where the people that want to have a say can be divided into those groups. We can do that after our meeting today, and they can get to work into smaller groups before we even have to come back here. There's no reason why we can't be working hard for the state of Mississippi, only in Senate Room 216. So I think that's a great idea, Justice.
And I should have said that in your packet at the first part are the relevant statutes related to all of these. So they're the ones that we came up with on that. And to that point, Justice, from the legislative side of it, at the end of the day, there's no point in reinventing the wheel if we don't have to. And sometimes in the legislature, the easiest thing is to simply amend one of the existing statutes. Rather than coming up with something completely and brand new. I just use that as.
I certainly agree with that. I also realize that we've got to work with the rules that we have in place, the rules of procedure, as well as our Uniform Chancery Court rules. Those are matters that are come into play, and it's going to take not only the legislature acting, but to make sure that whatever changes, possibly in rules changes, that those are also completed.
Exactly.
Good thing we've got Justice Griffiths, since the Supreme Court is in charge of the rules of civil procedure. I'm glad he's here.
Well, I guess I would, Mr. Chairman, then I would make a motion, we determine the groups or committees, I guess, subcommittees that we, of the issues to address.
Okay, so moved. We need a second. Are we doing Robert's Rules of
Second.
Orders?
Yes.
Okay, so we've got a second from Justice Griffiths. Any discussion? See if I remember my rules correctly. All in favor of not segregating, but dividing the individuals by groups of interest? All in favor, say aye.
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 Are there any opposed? Well, then let's go.
We don't have a lot of time. If we break ourselves up into 50 different subcommittees, we're not going to get anything done. Start with the biggest thing. Once we decide what the biggest thing is, go to the next thing. Once we decide what the next thing is, and then go to the last thing. In my view, the first thing is, and I think our chairperson, Chancellor Odom, knows much better than me. I would think Dean Bell and Professor Kennedy and Justice Griffiths and Mark Chin, everybody else in here would actually know too, but no fault divorce is what I've heard from both Senator and Representative have told us is the biggest thing. That's what we need to tackle first. Number two, guardian ad litem. These are binary decisions that we can either do or not do. If we or the task force provides answers to the legislature on child support, it's much more complex. There's at least three, as the chair has provided us, there's at least three concepts, not the least of one, which is implied that we go back to a different rate. As Dean Bell notes in her treatise, a different rate of the current child support. We're at 14% for 100 grand and below for one child. We started out 89 at 17%, which is what Wisconsin does. So I think my vote against this right now, Chair, is just because I think we can chop it down instead of everybody getting a little bitty axe and trying to knock down a redwood. We can all work on it at one time.
I don't think anybody's opposed to work it together with it now. That's what we're here for. But after this meeting is over with, after we've had a discussion as a whole, maybe having focus groups to take a look at it a little bit more. And if Judge McCarty wants to sit on all three, then absolutely, he can sit on all three. But Mississippi Department of Human Services may only want to focus on the child support aspect of it. I don't have any objection at all with having subgroups after we leave here and have had an opportunity to discuss it as a whole. That's what I think the purpose of this whole thing would be for, so that we can have the collective wisdom of all the individuals here on here. So any objection to that after we're done speaking here, having informal subgroups?
I don't think there's any problem with having an informal subgroup. It just, again, we can either go or not go. And I just think continuing to break it up, because I'll be real blunt with you. A lot of times I'm going to look for Justice Griffiths for what he thinks on each issue. He was really my paterfamilias when I joined the Court of Appeals. And then if I've got Professor Kennedy or Dean Bell, I'm just going to tell you, I'm going to look to them for everything. And so when I've got resources like this, I like the idea. And if we had 2 years and we had a lot of different time, but again, I just think for someone with my limited resources, just chop it down as we hit it. But that's just me and the way I think that we could do it.
Mr. Chairman, may I make a suggestion?
Sure.
Since I guess it's my motion. I would say this, that of the ones listed in that legislation are the ones, so no fault divorce, child support, and the bill that we talked about. Those are the ones the legislature felt was important enough to be addressed. And those would be the lists. And we just use those as the ones to address. So start with those. One would be no fault divorce, and then of those, decide which ones, which I think you already did. You said no fault divorce we discussed that first. So that would be the ones we need to address instead of, does that make?
It makes sense to me, and it makes sense that after we leave here today, to continue the discussion, whether in larger groups or smaller groups. It doesn't matter to me, so long as we're continuing the discussion and continuing the work. I would just like to get the discussion started so that we can figure out and start doing some work.
Then I would withdraw my motion on that.
Okay. Then let's withdraw it, and let's, as we suggested, let's talk about no fault, because there was a lot of consensus among practitioners and judges about the no fault divorce, being that some form of I keep saying no fault divorce, but it's all over the board is how they discuss it. Some form of amendment akin to what you see in Alabama or Louisiana it would be good to start the discussion in Mississippi. Maybe it would be good to hear from the task force members what they themselves think. Judge McCarty, have you given this matter any thought?
I have, buddy. And the thing is, I was a solo for 10 years, Judge, and we did a thing where I grew up called punk rock divorces. That's called nobody had any money. They had one car and they were going to fight over that. And the lawyer got nothing. You know, I did a lot of cousin divorces. I did a lot of that, Judge. And the reality is, with our socioeconomic profile of a lot of Mississippians, the number one thing we're hearing from Gayla Saunders at MVLP is, and I think Judge Schlegel and Judge, you would know much more than me, is we don't have people with attorneys in Chancery Court now. They've got two people who are unrepresented trying to get a divorce, and they're trying to get together to find out what a ground would be to access it. And so I personally didn't grow up, we grew up real heavy duty Baptist and did not like the idea of people getting divorced where I grew up. But with the landscape of Mississippi, what it is, and looking at the material provided by Senator Wiggins, I had never read these cases about irretrievably broken, and I'm sort of fascinated with the concept, where frankly, what that sounds a lot like to me is not a new ground for divorce, but one that could fit within our rules of equity if recognized by the legislature, and would then go under the normal scheme of abuse of discretion. If a marriage is irretrievably broken, I mean, I think it would be some kind of a ground, but I'd never heard that before. It doesn't have, candidly speaking, the taint of the phrase no fault, which turned off people in my community when I was running for office and different stuff, where they didn't like the idea of people getting divorced whenever they wanted, but the idea that a judge sat and determined that it was irretrievably broken, that seems different to me.
If I may, Mr. Chair, I practice in Alabama, Mississippi, Georgia, and Colorado, although I'm inactive in Georgia and Colorado right now. It's far easier to get a divorce in Alabama on irretrievable breakdown or incompatibility of temperament than it is in Mississippi to get the quote no fault divorce, because of the requirements of signatures for both parties. In Alabama, I can file my divorce petition, get it served on the defendant. We're in court within a month, and if nobody objects, we're taking testimony and they're going to get divorced that month. It just works so much better that way.
And I think a good person to hear from on this topic would be Judge Schlegel, since she has, well, we discussed the earlier opinion before you got here. Judge Schlegel.
Okay. And really, I want to direct this to Professor Bell as well. But it seems to me that all we really have to do under that irreconcilable divorce statute is take out the requirement of mutual consent and then add in possibly some time restrictions, maybe some other things like that to tweak it. I don't know, Professor Bell, what do you think?
Am I unmuted now? Yeah, what my understanding is that a lot of states do is they have grounds so that if somebody wants to file as an alternative on grounds, they can do that. But they also have, as you said, Donna, what's basically a no fault ground, even though it may be called irreconcilable differences or irretrievably broken, where that's an alternative. And so I do think that could be accomplished just by amending the existing statute to take out the requirement of consent and perhaps call it irreconcilable differences or call it irretrievably broken, which I think may to me, that's more definite. If it's irretrievably broken, then it means it can't be put back together. And I think in most states, if one party is convinced that a marriage is irretrievably broken, then the court accepts that testimony. And I wanted to add too, I don't want to take too long, but there are a couple of reasons I really support this. One is I don't think it keeps marriages together. I think it forces married people to live apart largely. And I think it's used as such a bludgeon in the negotiating process. But I also, like Gayla, really see this as an access to justice issue, and the impact on low-income people is really pronounced, I think. Thanks.
So if we change the mutual consent provision, then we would also have to modify the statute or amend the statute then to proceed, to allow one party to proceed on the issues before the court alone, or how would that work?
I'm not sure I understand. No, you would.
Well, not alone, but I mean, with just their, I mean, as it is now, we only need one complaint anyway. Nobody has to file an answer for divorce. But they can just proceed under a complaint for irreconcilable differences as the statute is now, without the necessity for consent of the other party, and then obviously give them notice and whatnot. And then they would, if they choose to do so, come and litigate the division of the assets, the child custody provisions, child support.
Judge, if
What
I
else
may.
would we have to change? I mean,
Judge, if I may, Professor and Judge, in Alabama, and again, I'm just throwing this out as an example for everyone's use. You serve the defendant, you file your complaint, you serve the defendant, and within 30 days, you have a court date that is etched in stone. You appear. If the other party or his or her attorney appears, you negotiate. And you do that every 30 days. Now, for the trial judges, I realize that creates an extraordinary amount of work, and y'all may not want to do it that way. But that's one approach you could use, is just maybe once a quarter, you have a court date to see where you stand. What's the status of this case? What's the matter? Why can't we get through with this? Just throwing it out there.
well, as of now, we have our 60-day provision. We don't have to change that. That's, I mean, unless we want to.
But I think you're going to have to take testimony on grounds under irretrievable breakdown. At least I think that's what.
Well, under our present statute, we wouldn't have to.
Okay.
That's what I'm saying. If we just leave our present statute alone and change the mutual consent provision and just either leave in a 60-day period, or I don't know, we can do something like Tennessee and some other places, which basically say, I mean, this is a little bit of a hybrid, but like, if there's no answer within 12 months, you just automatically get it on irreconcilable differences, or just leave it as it is and say, and just leave the 60-day time period. I don't know. What do y'all think?
It sounds like, Judge Slogel, what you're saying is what I would be akin to a unilateral no fault, meaning 60 days, that's it. Whereas in the state of Alabama, we've got this irretrievably broken requirement, which is, as I took it, a fault ground in Alabama, but it is just, it's not as strict as the habitual, cruel, and inhuman treatment ground that we have in the state of Mississippi. I think incompatibility is specifically stated in appellate court decisions as being not enough for a habitual, cruel, and inhuman treatment. But if we had a fault-based ground that stated irretrievably broken or incompatible as found by the chancery judge, that would allow it to be, divorces to be easier obtained for those individuals that absolutely do not need to be in a marriage. And then you have what you're talking about, taking out the mutual consent in the ID ground, but perhaps doing it like Louisiana, where you have you can get it with if there's been a separation of 6 months, if there are children involved, or a separation of up to a year, or excuse me, up to a year if there are no children involved, or I've got it backwards, a year for children involved, 6 months if there are no children involved, rather than just a unilateral, all you need is, taking out the
Yeah,
mutual
and
consent from ID.
That's what I'm thinking. I mean, I'm thinking the less we have to change or present the legislature to change, the better. Is that not, do you not agree with that?
Generally, that's.
I think it would be more palatable for the.
So, and then but I guess I'm concerned about creating a whole nother fault ground of it irretrievably broken. I'm very concerned about that.
That's a good concern.
Because of that.
But isn't that what the other states have is they've created a grounds for divorce that's the standard of which is pretty easy to meet, that one or two parties simply get up and testify, our marriage is over, it's destroyed, it's not going to come back. And those are the grounds. And so what I've read in these states that have irretrievably broken grounds for divorce, it's just simply an easy one to prove. So you can get divorced in 30 days, 60 days of proving that. And it seems that there are two ways to skin it. And one way is, like you said, keep irreconcilable differences and remove the requirement of mutual assent. And the other way is to create 15 grounds for divorce now and call it irretrievably broken, but set some standard in there as to what has to be proven. Is it enough for one party of the marriage to say, it's over, I'm never coming back? Or does there need to be a day limitation on that? I'm not real clear what the other states have done. I haven't studied it, but it seems both of those seem to be worth our discussion and worth presenting to the legislature. They're similar, but they're different.
Mr. Chairman, Matt, to your question, I think this is what was saying. Me personally, as a practitioner, it's the what I would call the weaponizing of the law that we have now with the grounds. And I think to the point of what you don't have that goes on in Alabama, because of course, being in Jackson County, we're close to Alabama, obviously, that for whatever reason, you don't seem to have that going on in Alabama. In fact, I know practitioners who tell their clients, go move to Alabama for 6 months and go file in Alabama. It's that much easier. So something is going on in Mississippi.
Mm-hmm. And it seems like like in Alabama, they're not really focused on going to prove this ground. I mean, it's just almost like a form. They just say it's irretrievably broken and that's it. There's no big lawsuit on it. So to me, the less that people have to go to court and prove, the better. Because the more you have to do that, then you are just ripping apart families. I mean, if they were already not in jeopardy in the first place.
And to that point, I've had clients come in where I told them, I don't see a ground. Y'all have to stay married.
Yeah.
And then that begs the question, is that even healthy for the kids, for the families in that they can't have that? They know it's over. They both do it, but I've had to tell them, sorry, you can't, there's no ground for divorce and y'all aren't agreeing on it. So guess what? You stay married.
Well, I mean, I just spent a week in trial on the ground of adultery. I mean, I haven't even ruled on it yet. I mean, a week. I mean, everybody's crying, all kinds of witnesses. There's a suicide involved. There's all these things. I mean, it's just why? I mean, it's traumatic. It's very traumatic to have to go through that.
And the kids have to end up testifying maybe. And
sometimes.
Mm-hmm. No doubt that Judge Schloegel and I have shared experiences insofar as we have held trials for divorces on fault grounds and are unable to grant a divorce under the current state of the law, even though we know staying in this marriage is not in the best interest of the children that are involved in that marriage. So I imagine, well, I know that I would be in favor of something akin to Alabama, which allows a chancellor to make a determination. It is irretrievably broken. These two parties are, I don't know the adjective you want to put in front of it, but incompatible. something akin like you have there, so that we can make a determination. It may not have to be a unilateral, no-fault divorce, which may not be palatable for the legislature, but something akin to Alabama or what we have in Louisiana, what they have in Louisiana, which allows for time limitations, would still make it easier for chancery courts to give relief to the parties and the children involved where we can't give it now. So I think we're in agreement that we need to have some form of it. What is it going to be?
Can I make a comment on kind of organization? I think, and Angela can correct me if I'm wrong, that the task force, I don't think it's expected that the task force actually draft out a bill or whatever. I think it's the concepts and then our job. So for example, let's just take this and say, the task force believes there ought to be something akin to Alabama that on divorce grounds. And then we come January, go back and we'll draft up the assuming that's what the task force wants, and hammer out the details and all that. So I guess my point is, certainly with everybody's time, we don't need to actually draft the legislation with this task force, but conceptually, if we can agree on those things, then that gets put into the report to the legislature, and then we will go and draft it.
I'm so glad you said that. So we've heard from some, and I'm glad we've heard from Judge Slogel and Professor Bell, but I know there's other individuals on this task force with thoughts on the no fault aspect of this.
And look, it's political. We've said that. I think Angela would agree, coming from people who are in the system, if these recommendations come forward, that people will understand, or at least the politics will be minimized on that. Just like Judge McCarty's saying, I mean, that's been the issue, but the reality is that, look, we have a citizen legislature, and not everybody, lawyers are few. And so we see it, but not every person. But I think we're the ones who are in there doing it. And so with a recommendation coming, if you will, then it's not just, Bryce Wiggins or Angela Cockerham. It's what everybody that's seen it. Does that make sense?
Hmm?
So I think that takes care of itself.
Judge Odom.
Yes, sir.
Can I speak? I'm Mark Chin. All I do is divorce law. Excuse me. I live this every day. First, let me say about myself, I've been married for 43 years. I have 4 children. I believe in family. I believe in handling my divorce cases in a way which leaves a family left standing, even though there's not a marriage. I have countless individuals come before me in marriages that are not marriages, day after day after day. Judge Bell talked about access to justice. The people that really get hurt are young women who have not worked for 30 years, people who have no way to get out. They're locked in and they come see me and they're in terrible situations, and I tell them, I can't help you. I might say, now there are lawyers who will file a cruelty complaint hoping that the other side realizes the marriage is over and agree to it. I said, but I'm not going to do it, because I'm not going to try a 5-day custody trial and not get a divorce. I'm not going to do it. One of the things that I've been reluctant to say, but I'm going to say it today, is that it lies to me in the definition. I don't understand why the courts decided to create a definition which is almost impossible to meet. The courts have done that, in my opinion. I have to prove, to get a divorce on the ground of cruelty, that it is dangerous to your health. Now, what is the definition of that? But the courts have made it almost impossible to prove that. So it seems to me, while I think the ideal, trust me, a divorce is not easy. It doesn't matter who you are. It is not easy. I've had many a person come in and sit down in the chair in front of me and just burst into tears because they don't want to be where they are, but they can't stay in their marriage. I think that what we should look at and I used to be a legislative draftsman, and I'm aware that you change as little as possible. And I just wonder, while I think the ideal might be to have something, what I've heard about Alabama today, that might be an ideal. I would love to see it. What about defining habitual, cruel, and inhuman treatment for the courts in a way which will allow us to get a divorce in these marriages where they are truly not good marriages, and the judges know they're not good marriages, but they're not bound by this definition of habitual, cruel, and inhuman treatment, which is impossible to meet. Corroboration. How many times have I had someone in my office tell me what's going on in their marriage, and you know it's not a good marriage? But I said, well, who's heard this? Well, no one except my 8-year-old. You can't put the 8-year-old on the stand. Corroboration, danger to your health. How do you prove that? So I would like to see us suggest to us, while I'd like to have the Alabama law, I'd like to suggest that we look at a definition of habitual, cruel, and inhuman treatment without changing the ground, but we define it for the courts so that people that are in bad marriages can get a divorce.
So you see modifying that, keeping our ground statutes, maybe modifying that one, and also modifying the irreconcilable differences one as well?
I have no problem with modifying irreconcilable differences. When you proposed it, I had never thought of that. And all I keep thinking is I wish I had the statute in front of me so I could look at it. But if lawyers knew that it wasn't just about impossible to get a divorce on cruelty, everything would change. And the blackmail, the leverage that goes on with the you can't prove it in these divorce cases leads to horrible results. I've had women come in who have 3 children and took just about nothing in order to get divorced because they had no other way out. And I tell them, sorry, bad deals can't be fixed. That comes from this habitual, cruel, and inhuman treatment definition that we have. I think if we redefined it for the courts, again, I don't know why the court's chosen to have such a tough definition, but if we redefine it for the courts in the legislative process, I think it wouldn't take a whole lot of redefinition to back us out of this complete deadlock that we have in terms of getting a divorce.
Well, I mean, I see cases that are on domestic violence, for example, where the legislature branch did amend that statute that did away with the requirement of corroboration on domestic violence. Well, that's fine, but you still have to come to court, get on the stand, go over the gory details. It's just it's painful. Why? It's re-traumatizing the victim in a sense. So now you don't have to call other witnesses, but why go through it? Why not just plead irreconcilable differences? There's no mutual consent. I mean, sometimes you can't even find the other party. You have to publish. And they're nowhere around. I mean, they're gone. Why go through it? That's my... So to me, that's why I have no problem amending that even further to give a broader definition, but why not just take out the mutual consent provision of irreconcilable differences and just leave it? And let people just, you can still, as we sit here today, you can still consent for the court to adjudicate all the matters of the divorce. The custody, the division of the assets, all of that can be consented under the ID statute.
Judge Odom, I think right now, and I'm trying to take notes as best I can, but I think right now I'm actually hearing, and just to refresh everybody, Mr. Chair, I think I've actually heard 3 separate discussions. There's one from Judge Schlegel that's roughly, and I don't want to over summarize it, Judge, but it's to change our consent requirements to make it more accessible for irreconcilable differences. There's one, like we talked about, Alabama, which would be to create a ground for irretrievably broken. And I think perhaps, and I'll try to quit saying it, to avoid perhaps the language of no fault, it would not be no fault actually as these states have it, because the chancellor would have to determine that they did access the irretrievably broken ground. And third, I think Mark or Mr. Chin brought up the idea of broadening the legislature broadening the definition of habitual cruel and inhuman treatment beyond that which currently recognized by the Supreme Court. So I just wanted to put a pin in it, boss, where we are right now to say, I'm hearing three different things, I think, actually.
And I don't even know if we're hearing three different things. We may just be hearing two different things. Mr. Chin and Alabama, I think, are the same. It's just how are you going to work the irretrievably broken into it? Whereas Judge Slogel, and she, correct me if I'm wrong, you're talking more along the lines of a unilateral, irreconcilable difference divorce where you do not need the consent of the other party in order to get it.
Yes, that is what I'm saying. I mean, you can still come to court and litigate all the other issues that you may need to litigate. But as far as getting the divorce itself, you're not locked in to the marriage.
Professor Bell, you're
Yes,
going to say
I
something.
wanted to be sure that I think there's yet another option that I'd love to see us discuss as we go forward, thinking about what's likely to pass. And what I hear from Judge Slogel is something where it is unilateral in the sense that one party can control the result. But I hear also people saying, well, if it's not no fault, that would be helpful. So I think this is what Louisiana has. There are some states that have, it's in the fault grounds often, a ground where one person can get a divorce if they can prove that the couple have been separated and living apart for 6 months, or sometimes it's longer, a year if they have children. But that, I think sometimes when I say that other states have unilateral divorce, I'm including that. And so I think that's why it's sometimes misleading that these states, I think, tend to treat it as a ground. But there, if you have someone who is a victim of domestic violence or who is unable to get out, at least they know that if they separate and stay separated for a set period of time, they will be able to get a divorce. So I think that's another option. And I think somebody had mentioned that earlier. I just wanted to be sure that was still on the table as well.
I see that as an option. Excuse me, Judge Slogel, go ahead. I see that as an option, but I would like to steer away from separation for a period of time because people don't have the means to separate so often, and they are trapped. And it's going to be people without incomes, or a woman who's given her entire life to raising a family, and she's 55 years old, and she's been shut out of the finances by the husband. Not that guys are always bad people in the deal, but that's a likely scenario. They have no way to separate.
So you're talking about when they come to you and it's a terrible situation. They're living in the same house. They don't have standing to say they've been separated for 6 months. So they can't file under that if that were the case. They have to just file under a fault ground. So to me, again, if we just modify the irreconcilable differences and take out the mutual consent, or even modify habitual cruel, then you would still have those situations where I guess what you could say is you could start out, you don't have to start out with separation, but if you go through the litigation and nothing is resolved after 6 months or after a year, you automatically get it.
That sounds good.
Take out the word obstinate from the statute as far as desertion goes. That's the hook. Would you take them back? The key question in a desertion fault ground, as far as I'm concerned. If you take out that, then you leave the 1 year of separation. And like Professor Bell pointed out, 6 months if there are no children involved. That would make it easier for an incompatible or irretrievably broken marriage to obtain a divorce.
Well, that's true.
Legislator continue or to consider.
And let me add one more thing. I personally, if I thought that it would pass, my personal preference would be a unilateral no-fault divorce. I didn't want you to think I was advocating for that, but if there's a concern that it's not going to pass without having more limitations.
But I think that the standard for divorce should be, first, if both parties agree to get divorced. That should be the easiest and best way to do it. The second way is what to do if one party is obstinate and not willing to enter into the discussions and have a divorce. Maybe it needs to take a little bit more time to think, and there needs to be a little bit more. These are all grounds for divorce. I guess the only problem I have, being one of those court people that interpret this, is when it's habitual, cruel, and inhumane treatment. It is inhumane treatment. It is something more than just rudeness. And so I agree with Mr. Chin that some of the definitions can be created and more defined by statute to make it easier. But I think there needs to be a flow to whatever you do, that when parties come to your office and say, we want a divorce, we should reward people who are willing to agree to a divorce. Every part of it, agree to get divorced, agree to property settlement, child custody, and child support. Those people should be rewarded in court. The people that disagree but still can show that they have no marriage that's going to last, that's when these kind of no fault light, grounds light, I guess you would call it, come in to prove that we can't live together. So how do you establish we can't live together? Just go to the judge and say, if we can't live together, one of them. And I think that's why they require some term of living apart. And then you still got the grounds for divorce, adultery, habitual cruel and inhumane treatment, desertion, all of those that can still go to the chancellor. But I'd be willing to bet that very few marriages in Mississippi go all the way to grounds for divorce, at least the ones that we see that are appealed. It seems to me that most are coming at some point, irreconcilable differences. Eventually, the parties agree to the divorce and submit the other issues to the chancellor. So, well, I don't have a problem with any of these. I think we need structure, and the structure should be, if both parties come in and want to get divorced, what prevents them from getting divorced the next day, 30 days later, 60 days later? It seems to me that the recommendation should be, how do we make it not only easier, but when the parties are adults and they can take care of their business, we allow it to happen.
Mr. Chairman, Matt, just kind of to the earlier point, I don't want to cut off discussion, but just to remind that it's the points about what our recommendations are, and then the details like that are either, that was kind of what I was alluding to, that when we can come back and flush those out, take the details out with the next time.
Sure.
And I'm just being considerate of time and everybody's schedule and all that. And I was talking to Ian over here. He's used to listening to this. And so I think he was saying the Alabama statute, it seems like a lot of people that maybe we could pull that, submit it to everybody, and then that's a way to work through that. You're the chairman. I'm just throwing.
Well, we've got a lot of great and experienced individuals on the task force. Is there anybody else we haven't heard from yet that would like to say something on the issue of the no fault divorce aspect of this task force? All right.
I'm going to have to add one more thing at the risk of talking too much here, but just to take up something that Justice Griffith said. You want to reward people for agreement. And I agree. I certainly agree with that. I mean, especially as a chancellor. But the problem is that you want to take away the bargaining chip of saying, if you don't agree to give me the kid, if you don't agree to give me alimony, if you don't agree to give me the house, I'm not agreeing to the divorce. And that's what I think we have to take away. So yes, you might see an agreement and you might get a divorce under irreconcilable differences with an agreement. But a lot of times it has been, I don't want to say coerced, but there's been some heavy negotiations on it. And a lot of times it's just not fair. And it went through a lot to get there. And your alternative is to say, under irreconcilable differences, is to say, okay, can we agree that the judge will decide these issues? Well, yeah, a lot of times they will do that, But in several cases I've had, this is what they'll do. You'll come to court, they'll agree for the court to adjudicate everything but alimony. They'll say, I'm not agreeing to alimony. So the court can decide everything but alimony, and we'll start this trial, and they have a consent to adjudicate in writing that says the court's going to decide custody, child support, division of the assets, but not alimony. And they continue on, and then you get midway through the trial, end of the trial, and then one party says, that's it, I'm withdrawing my consent. I want alimony. See, that's the blackmail. And they withdraw their consent, the trial is stopped, and you've just spent years in litigation. I've had cases where you've spent years in litigation. Mr. Chen, why don't you tell me this is true? So that's what I would like to see stop. And if you take away the mutual consent provision, nobody can do that.
Yeah, I don't disagree with that. What I was trying to say is that from the way it should be set up is that if the people agree without coercion, they should be rewarded.
Right.
The coercion and the blackmail is what needs to be removed from the system. I think we all agree that we wouldn't be sitting here talking about no fault divorce if people would agree to irreconcilable differences when they should probably agree to irreconcilable differences divorce. The problem is now that part of the strategy is how do you economically blackmail someone? How do you economically blackmail your spouse with the custody of your child or child support? And there's coercion that's involved because lawyers have figured out how to get the best result for their client. My comment wasn't to say that we should leave coercion. It's to say that if you were dreaming up a divorce scenario or a divorce scheme for statutes, you would want to first create a scheme where if the parties come to court and honestly agree to all aspects of it, those are the people that go to the front of the line. The people that cannot agree, the coercion needs to be removed. And that's where maybe it needs to go to a unilateral. You can get a divorce because it's irretrievably broken, but you still got to deal with all the property issues and the child support and the child custody. And those are matters that are probably really more important than the divorce because the people are already divorced. I mean, they may live together, but they're divorced. They're not living in a marriage. And so you really want to get to the other issues, the property, child support, and custody.
Absolutely. And that's what they need relief from or for. But going into, taking away that sort of blackmail, that's what keeps, just fueling the conflict. Of course, if there's children in that marriage, the children are suffering because anytime there's parental conflict, they're going to feel the tension, and it just continues on. But I want to point out one of the chancellors at our bar convention meeting, he said, well, Judge Slocum, you're going to have to hear all that stuff on fault anyway. And well, that's true. When we do consider fault in the equitable division of the assets. We consider fault on child custody, all of that. So we can hear all of that if the parties want that to be a part of the court's judgment in equitable division of the assets, but it won't stop the divorce. And that's the key part, is that one person can't say, we're not getting a divorce because you don't agree with me.
I haven't heard anybody say that they were against a unilateral agreement for either irreconcilable or irretrievable divorce. I haven't heard anybody say, no, we should stay with the fault-based grounds or require agreement. I haven't heard anybody say that. The second part would be then, okay, do we believe that there's a waiting period necessary? Different states do it up to a year. What would be the appropriate waiting period? Is it 30 days? Is it 60 days? Is it no waiting period? Because if you file for divorce and if you agree, do you have to wait 30 days to get a court hearing before you can act on the divorce and I think they call it, Mr. Chen, a cooling off period. Isn't that kind of what the literature says? The reason for the waiting period is to give the parties an opportunity to have done this action, and that is file court papers, serve court papers, and then they've got to cool off for a month. And during that month, decide, is this something truly we want to do? And most of the time is yes, but there are a lot of divorces that are still on the books that no action is being taken because they've gotten back together. So what type of waiting period do we want to include it? Or would be proper?
Yeah, so do you think we should keep the 60-day period as long as there's a mutual agreement? And then say in the event there's no mutual agreement, we set in a time frame like a year or 6 months, 6 months with no children, a year with children, where if you're automatically entitled to it then?
I think we've come up with really one of the first recommendations, and one of the first recommendations deals with how to deal with deal with the divorce. And I think the time period would be a legislative decision, one that could be either shortened or lengthened based on what it takes to get it, because the people that are going to say this is anti-marriage are going to want a longer, I mean, that's a negotiating point, are going to want a longer waiting period if they agree to it. And the people that are not are going to want a shorter waiting period. So I mean, I think we've kind of agreed on something. We've just got to come up with proposals and circulate those proposals. And I don't think we get to decide whether it's 30 days, 60 days, 90 days, or 1 year. I think we can make a recommendation. But I think we've got really two things to work on. One is, how do you change the irreconcilable differences divorce to allow it to become unilateral? And second is, how do you draft a proposed ground for divorce called irretrievably broken or incompatible that would lower the evidentiary standard to allow the chancellor to declare a divorce based on the fact that one party is saying, I hate that guy.
And I think if nothing else, we've sort of made it a point to the two legislators that are here, that it appears there's a lot of consensus about the need for changes in the law.
Yeah, clearly there's consensus that something needs to change.
Well, is there anybody that's on the task force that we haven't heard from yet that has an opposite view? I want to make sure everyone has the opportunity to speak. Senator Wiggins, Representative Cockerham, is it possible to take a short recess? Absolutely.
Yeah, please.
Let's take a short recess and come back and tackle child support.
How are you?
Good to see you. I love Zoom. Trial. Motions. We had a visitation issue at Jason Hattiesburg. They were Humphreys, Gulf, Jackson, Judge Sheldon, 50 Zoom. I said, she said, anything else? Thank you.
This is great. Yeah.
How you doing? I want that picture you put up there when you were driving. With your hair kind of flowing. I want that picture.
Kind of a little.
I mean, it's a good one. It looked like you were in your car and you just took that.
No.
It's the natural beauty.
In the courtroom now, we have a monitor, a screen, like, I don't know, bigger than that. And so we let people now in the courtroom. So I much prefer being in the courtroom, some witnesses sat up here. Well, the bailiff, they all try to get it set up in the morning. Somebody's here about Zoom, so they have it already started. But the color has that picture. And it's like huge. I mean, I walk in the courtroom, I'm like, is that necessary? Everybody starts laughing. And then what? Lawyer was like, "Look, Judge, I was about to swipe left." Swipe right, yeah. Swipe right, you like somebody.
Oh, no, I didn't know that.
I don't go to dating apps, so I didn't know that.
I didn't know that.
It's a good thing we didn't know that. Mark.
Surprised to have heard it.
Lawyer, and he was like, "Yeah, Judge, I was about to swipe right." I was like, oh my God, this is in front of 20 people. I'm like, take that down.
I did a
Take that down.
CLE virtual with the defense lawyer, an hour long. I was the first one to go. And so I just gotten, I need to figure out early on, and one that great for Zoom. There's a picture right in front. They introduced me to looking at me, and they introduced me. And as soon as they introduced me, he leans back in his chair and lifts his head back. And so I'm looking at his nose, and he's got nose hair going every different direction. And he closes his eyes. And all I'm doing is watching his nose hairs move back and forth because he's got it so close. And that's right there where the camera is. It's right below the camera. And so I'm sitting here trying to do it, trying to look to see how I can adjust the panes on there, the different views. And so I went like 20 minutes just watching this guy's nose hairs flutter throughout. I said, from then on, I stopped and I said, I'm going to sit out here and learn how to use Zoom and control every aspect of this. I don't ever have to wait up on it too. That's right. And then I started thinking, how do you look? Does it matter?
Yes, it does.
And I do class with so much too. I do Zoom in class. I do rural lady. She had the laptop laying in her fully clothed, thank goodness. Laying there, I thought, how inappropriate is that? I got to look at this.
But what about if you're,
Just show me the wall.
yeah. So, but it's one thing that conference committee, what if you're trying to have court, you're having an emergency hearing, and just like he said, his face is in the, he's making faces at every single thing, everybody says, and then he's walking around outside, and I said, you know, sir, sit down, you're in court, I know you don't, it doesn't feel like you are. So sit down, stop walking around, stop making faces in the back, or I'm gonna turn you off. Like you're gonna not be allowed to speak. It's like,
Sometimes it's worse to turn them off because then you don't know if they're really paying attention or not and how they're participating, you know? I mean, you want to see it. Well, it's
Dog barking in the background.
but their license seems to we don't use it. We don't.
Positions. I know there's some downsides to it. Lots of travel safe. You don't know what they're looking at. Somebody's leaving some information. Right. So you gotta be careful when you do it. I hope you don't say this.
You can't see. They can have a phone in their hand. Somebody can be texting.
Right.
Students, because I've seen my son, I mean, he's in law school and they are literally texting each other going, don't ask this question. Don't do that. We need to get the class, you know, and you're.
Is he an old man?
No, Jackson.
I got a daughter.
He's not in my class.
He's a third year. What
He ought to be
class?
Mississippi practice.
I wanted him to
He
get.
ought to be learning how to practice in Mississippi. I think so. I'll have to look at my role. I didn't pay that close attention.
I wanted him to get.
Get called on, man.
My oldest son just started law school in Chicago.
Northwestern?
No. Only one left.
Chicago Night Law School?
Well, he's in Chicago. He got a degree.
Waiting time to be able to get before the court is longer, not that they have to separate part of it.
In the case of unilateral,
When you run for governor?
I think the people of Rankin County give a care.
I do. I think your wife would understand this way. You might be a shooter.
She'd be a better governor.
She would be.
I'd be a good first man. Let's put that one.
She would be. Well,
Thanks. All right. Y'all ready to get back?
Y'all ready to get back to work? One of the other, we'll get back to work. One of the other topics that I know that people, that was on the top of people's minds that was in the bill was the way of calculating child support. Y'all are aware that in the state of Mississippi, I think there are 8 other states that use the percentage of income method of determining child support, which is simply applying a percentage, a statutory percentage to what the adjusted gross income of the non-custodial parent is. That's putting it roughly. Many other states, I want to say 38, use a shared income model. There are 3, I believe, that use the Melson model, and I appreciate y'all putting the definitions and the materials that have been provided to us by the legislature. And I'm glad to hear Senator Wiggins and Representative Cockerham, y'all state that these are matters that come to y'all frequently year in, year out at the legislature. We don't know these things as humble Chancery Court judges. I had no idea that this was such a hot topic at the legislature. And it really opened my eyes to the other ways of calculating child support. And I'm sure that using both parents' income in the calculation for determining child support was a selling point, or is a selling point, to a lot of your constituents. Is there anybody on the task force that has looked at this and has an opinion and would like to express it?
From the agency's perspective, I've looked into this, and I think that we're going to be open to whatever this commission recommends. We do have some concerns about the shared income model. Not that easier is better, but the percentage of income is very easy to apply. And I'd also note on page 26 of the packet that we have, there's a comment that says, it's worth noting that in most cases, this model will produce the same result as a simpler percentage of income model. So based off of that, and we also have some concerns about the administrative burden of this change, which all that to say that the agency is certainly open to the discussion, and we will go with whatever the task force recommends. But I don't think that there's a perfect model, and I think that there's benefits to both.
Mr. Chair, again, if I may, while I agree with what Mr. McCauley has said in some respects, I find that the percentage of income, total income model is equally well easy to provide if you have the appropriate paperwork. And in Alabama, that's set out in their rules under the child support guidelines. You simply, if the people make $5,200 a month, You go to the $200 a month category and look at the number of children, and it tells you what the child support is. Then, of course, you have to break it back down. But what I really like about that model is that if you pay childcare, it's taken into consideration. It comes off your end of that payment. If you are paying insurance, it comes off your end of that payment. I think those are things that we have to take into consideration, because the child insurance is exorbitant. And some of our obligors are paying $600, $800, $1,200 a month for insurance alone on top of that child support. And I think that's something that this legislature has to address.
Justice.
I was just going to ask a question because I don't know. But how under the income shares model does it work when one party is not present or is not participating, or you don't have the information as to what their income is?
You're asking a question to a chancellor that has applied solely the percentage of income model his entire career. I don't know. Is there anybody that has got experience in applying the income shared model that could answer the justice's question?
I do, Donna Smith, Mr. Chair. And I do this routinely in my Mississippi cases because I don't trust defendants to tell me what their true income is. I use a subpoena ducis tecum. You get their income information that way. Alabama has there are 3 or 4 different forms that have to be filled out and signed by both parties. One is a affidavit that verifies your income, to which you attach your paycheck stub or your IRS forms returns. It's not a difficult procedure.
I've also heard other states imputing the custodial parent, and so that's another one that I think they deal with, it is imputing income.
I would like to offer my insight in terms of where Social Security payments and child support collide. However, from what I understand, at the beginning of the meeting, we will have an opportunity to perhaps submit things in writing at a later date and meet later to discuss about it. I would like to present the facts and the outcome of a particular case that I was faced recently at the appropriate time.
It would now be the appropriate time?
Sure.
Okay, sure.
Yeah.
Well, I'm sorry, I didn't mean to interrupt you.
Go ahead.
Well, this is in regards to an elderly man that owed a significant amount of back child support for adult children that he actually raised in his own home. However, there was a child support order in place. He got to the point where he had to be admitted into a nursing home. When he was approved Social Security benefits, all of his benefit payments went to the mother because of that old child support order that was already in place. Although he raised the children, he never went back to court and got a modification. Well, at this time, his sister was his caretaker, and she did not have the means to pay for his nursing home bill. DHS, well, all of his Social Security, his monthly Social Security payment was going to the DHS payments. So he didn't have anything left to cover his nursing home payments, and his sister was left to take care of him, but she did not have the means to do it either because she had to work. There was just no money to support him, considering his health conditions and the dated child support order. I just feel like that needs to be addressed by the committee as well, because I've also work a lot with Mississippi Center for Legal Services, and that comes up a lot when it comes to when it comes to child support, old child support orders and disability payments.
Yeah, certainly the collecting of child support, I'm sure, is a topic on the top of the legislature's attention every year. But since the Senate bill that formed the task force wanted us to look at specifically the three models, I wanted to make sure we hear from the members that have had an opportunity to look at those three models to see if they have an opinion one way or the other that would be helpful to the legislators.
Mr. Chair, I'll weigh in on this because I think that, I mean, certainly as the initiator, I guess, of this. So a couple things that I was a little surprised too when we started researching it, that the income shares model, if I'm saying it right, just from a legislative perspective, when you see that 38 states are doing it, that tends to tell as a legislator something is either right about it, or at least that's been, not that it's the only way to do it, but that 38 states have decided this is the best way to do it out of 50. So you look at that, I mean, look, we stand up in front of our bodies and go, yeah, 22 other states have passed this bill, so let's be the 23rd. I mean, that speaks to us that we're not plowing new ground. Second, excuse me, that I think somebody said from a perspective of practicing, I personally, both as a senator and as a attorney, have heard complaints. And of course, there's always an extreme on one side or the other, but the differences in income has always gotten complaints put to me. In particular, the examples of like the non-custodial parent it can be one of two ways. You know, one's a doctor and the other's, you know, not. And the doctor's complaining because they're having to pay all this money and they don't have the custody of the children, when the custodial parent remarried and they're married to somebody that can afford it and they're not doing their share or whatever. Or vice versa, that the non-custodial parent is having to pay and it gets to the end where they just can't pay anymore. I mean, we can say what it is, but they just can't pay anymore. So, and I haven't gone necessarily beyond all that, but what I do think is if 38 states, because I'm just reading it here, it says that under the income shares is calculated based on a set percentage of the combined income of both parents. The reality is that I think the model that we have now was done, I don't know, 20 something years ago. The reality of what a family is nowadays is changing, or it has changed. Y'all may know that better than I do. And you have two working parents, or, I mean, I think back when this was done originally in Mississippi and other places, you had one primary caregiver, primary working parent who was responsible for all that, and one stayed home. I don't think that's necessarily the case anymore as much as it was. And, but I'll also say this from my own perspective, shoot, I couldn't do what I do without my wife working. I mean, having two working families. And what this says is calculate of what that income of both parents. And I did do a little research. I think some states do it like what the parents, they take their current jobs and they look at both of them, or what they were when they were married and all that. The bottom line was it was two incomes versus just one taken into consideration. So I haven't really gone beyond that, but that was part of the reasons to look at it, that it was there. I do think the Melson seems to be completely an anomaly based on the states. So that may not be something that we would be open to. So that's my comments on that.
Mr. Chair, may I also add, Donna Smith again, sorry, I'd like to talk, I guess, that a lot of times when the custodial parent is expecting that the non-custodial is actually going to exercise visitation and absorb some of the cost of rearing those children during visitation. And in reality, after about 18 months, a large number of non-custodial parents rarely visit. And I think we may want to consider number of overnight visitations as some sort of incentive to lower or increase child support, because if I have my child 365 days a year and you're paying me $150 a month, you're not doing me very much good. And that's what $150 a month is minimum wage, is child support based on minimum wage, y'all.
Agency's perspective, we don't deal with custody or visitation. But I would add, from what I've read, a shared income model makes it easier to calculate shared parenting time. And I'd also offer, I was at a conference recently, I think Arkansas was the latest state that went from percentage of income to shared income. A colleague there pointed me out to their website. They have, usually when a state switches models, it uses what's called an economic impact statement, and it requires getting a consultant. But all of those examples are on Arkansas's judiciary website, and I can find the link and share it with everybody if anybody would like to do some further reading.
Can I ask DHS, because clearly DHS, it's a big issue, DHS, whether one works better for DHS, because they see a lot of it.
Sure. The question, I mean, and you may have even stated it when you made your earlier comments, what DHS's preference was.
Like I said, we're going to be open to whatever the task force recommends. Like I said before, easier is not better, but it's kind of what we know. We have serious systems limitations. We have what's called a legacy system that's over 20 years old. Making these changes, we can do it. Other states have figured out how to do it, but there's certainly cost involved. I don't feel comfortable giving a recommendation of what the agency recommends. I prefer to see a discussion and talk about it.
Okay, I'm going to put you on the spot. So,
Okay.
But of the people that you see, setting aside the cost of trying to change your system of the non-custodial and custodial parents that you see, is it better or worse that you're looking at a 2-income calculation?
I think there's a perception that with the shared income model, there's a greater amount of equity. Just that when you're considering the income of both parents' income, that there's this perception that shared income is more equitable to everyone, that it allows, there's another component to this on setting up what's called a self-support reserve. And so somebody mentioned for the non-custodial parent, you don't want to take so much to where when the child goes back into his home to visit, the child doesn't have the same standard of living there either. Equitable is kind of a vague term, but whenever you read about these models, that's what you hear, is that shared income is more equitable in a lot of ways.
Yeah, I can speak for Chancery Court judges. It sure is easy to apply a percentage to what the AGI is and to set child support. It's one less thing for us to do. That doesn't mean it's the right thing to do. I'm glad we're looking at the issue.
Can I ask a question to DHS? If there are 38 states that use the income shared model, do they have a standardized type of computer system that we would be able to purchase that might actually lower the overall cost and help administer these claims better?
That's a very good question. These child support systems are extremely big and cumbersome and old. I don't think that they might have something we could model. And we're currently in the very, very early stages of looking to modernize our child support software system. That's an extremely long process. So we could get some models from other states, but it's not like a plug and play where we could just take their system and plug it into ours.
So there's not a commercial system available?
No, not that I'm aware of.
Thank you.
Judge Odom, I'd just like to say from the House's perspective, with respect to a lot of the bills that I have seen and that have been introduced, there has been an amendment to revise the percentage with respect to the income model for the state of Mississippi. Now, I do share a concern that Justice Griffiths asked earlier with respect to the income shares model, what do you do if you don't have the other income? That would be my concern for the other parent. And then having practiced in this area too, especially with COVID, and that may be one of the reasons why there was a great influx of the bills that were introduced in 2021. I don't know with respect to the increase for the income model, but even with COVID, only the good Lord knows how long this will be with us. But I do have some concerns too with respect to whatever direction the task force recommends and what implications that may have with respect to the recommendation that we advance as well. Because if you go with, say, for instance, an income shared model, and we're saying we're basing this on 2 different incomes, or even if we decide to increase it. And I think that's why Bryce's question was so important too, with respect to DHS. Well, what do you recommend? Then definitely, and we see a lot of bills too, with respect to, well, if a parent isn't able to pay child support, then what happens? So we see a great number of bills. So I definitely think that whatever the recommendation is with respect to, if we change it, then there's going to be a cause and effect with what happens if you're not able to pay it too, from that perspective.
And I think there's a concern, at least from the court standpoint, about the 805 financial statements and what exactly is provided to the court in order to make the determination. Both sides provide good 805 information. It's pretty good decision, but we also need to consider those 805 statements and what they request. And are we asking for too much, or is there a way to streamline that under the income shared approach that may make it an easier calculation?
Judge,
if I may add to that, just to kind of simplify. So if you're looking in this chart that was in, we handed this out ahead of time, actually, when the bill was coming up. But the bottom line is, if you look at that, how they've simplified it, they're actually taking the non-custodial parents' income and you take the custodial parents' income, which actually ends up making it a monthly income of $3,000, which is higher. And then it's basically a 60-30 split or 70-30 split. And DHS said it's the consensus is it's more equitable. I guess I would be arguing that it is more equitable because they both participated in bringing this child into the world. So why should one parent be the one having to pay for 100% of everything?
But I think you assume that the information of the income is going to be easy to obtain. If both parties have a job, that's easy.
Agreed.
The problem is when somebody's working in a second job or they have a cash job, and kind of the coercion under the income shared approach is that the custodial spouse is going to try to drive their income down as much as possible, because that increases, the more they drive their income down, the more it increases the amount of child support. And so, you don't want parents forgoing income opportunities in order to increase their child support opportunities. But that's why, part of the discussion, the concern I have in income shared is that we're percentage of income, we're totally focused on the non-custodial parents' paycheck and compensation. Under the income shared, we've got to have a system where both parties' financial information and correct financial information is before the court. And so it creates a little bit more opportunity for child support fraud.
With all due respect, I see that every day. I see people lying about their income, and half the time can prove that they're lying about their income. The other half, I know that they're doing it, but I can't prove it because they're working under the table.
That's where
So it affects both models.
Statute, where Alabama has a thing essentially that it goes to their trial judge Because I just read that, Justice Griffiths, when you were talking about it, where the trial judge can go and figure out and say, kind of like how we do here, and say, well, they're underworking, they're underreporting, it's a cash business. But I'd like to really ask, I only ever did trial court divorce work as a lawyer. And so now see it at a totally different level. I'd like to ask Judge Schlegel and Judge Odom, I mean, do you see anything wrong? And this is really in line with what Representative Cockerham was talking about. Do you see anything wrong with the 14% non-custodial parent rule as we have it now? Is there something in your courtroom where it's not working well, or you feel like it's not equitably leveled in families? Because I'm really curious to see, after learning a lot more about this, and for lack of a better term, how does it feel in your courtroom?
I'll let Judge Schlegel go first if she so desires.
Well, I think it may be low, and we haven't raised the percentage in a long time. That's one thing. When we don't have proof of income, of course, the chancellor can impute the income. And so a lot of times we're just imputing minimum wage. But if we know that there's more income out there that is just not being reported, then we can try to impute it other ways, by looking at past tax returns, by looking at income from the past, that type of thing. So I guess, I mean, this is different from what DHS is considering. I would like, as a chancellor, to be able to consider the income or the assets, let's say, of the custodial parent as well, to be more equitable, but I'm not sure about how to, if it's good that it's mandated. That's where I'm having trouble with it. It would be good if it was an equitable consideration, certainly in some circumstances. But of course, I don't want to create the incentive, like Justice Griffiths was saying, if someone just lowering their income as much as they possibly can because the custodial spouse is able to do it without them. People do what they have to do, but we want incentives for them to certainly to participate. And we don't want to disincentivize custodial parents. And then you get into, some custodial parents are remarried, then they have the additional support of a new spouse. And then that's where you see the non-custodial parent drop off a lot of times too.
And I think we need to make clear is that nobody's arguing in here that the custodial parent bears the burden, the overwhelming burden of raising that child, not the non-custodial parent that's paying child support. That's a drop in the bucket to the real cost of raising a child. Nobody's, I don't think, arguing that. And it does sound great when you can say that you're taking into account what the custodial parent makes. It does make it sound more equitable, but from what I've seen so far from running my own models and from the information provided to us, like DHS said earlier, it's not going to be that different in the long run as to what we have now with our 14% for one child. To answer your question, Judge McCarty, I don't necessarily see an issue. Judge Schlegel is correct. Mississippi's child support is probably lower than what other states would require a parent to pay under the same circumstances. But that may be because Mississippi is one of the poorest states in the nation as far as income. There are probably a lot of things that go into that geographically or economically, but I don't see necessarily a problem. It has worked for us in the past. The real problem I see is collecting it for the custodial parent to have so she can or he can use that for the benefit of the child. Hope that answers your question in many words.
Can I make one more point? I mean, I think under the current guidelines, chancellors have the discretion to take into account the CP's income. One of the deviations you can overcome the presumption of the guidelines by looking at the total income of the NCP, the CP, and the child. And so I don't see it used a lot, but the tool is kind of already there within state statute.
Yeah, the chancellors do have the discretion to deviate from the statutory guidelines. However, there is language that says you're not supposed to if it's within a certain range. I can't remember what it was, 10,000 to 60,000 AGI.
Yeah, no, but in addition to that, the chancellors can look at what they call, I don't have the language in front of me, but it's the total income of the NCP, CP, and the child.
If I may add one thing, and I was just asking Angela, certainly hearing what y'all are saying, the reality is we're getting these bills on the percentage at a minimum. And so the question is, why are we getting, they don't, and I'm not putting, also the task force doesn't have to make a recommendation. And if that's what the task force says and that it's not a problem or we don't need to address it, that's totally fine. But there's some reason these bills are coming forward.
So what are they? It's to lower it or to raise it or
Generally to increase it.
to increase it? Okay.
To increase it and to increase it.
Well, I think one thing the agency has tried to submit in the past is increasing percentage, but lowering the age of majority or the age of emancipation. And so Mississippi is one of the few states where it goes to 21. Most states are 18 or 18 plus if they're still in school. And so that was kind of not a compromise, but a way that we tried to sell it before would be we need to raise the percentage, but we also, to get in line with other states, we need to back off 21 years age of majority.
Can I weigh in on that for all the chancellors? I think that was a consensus among all the chancellors that we do not want the age of majority lowered below 21. Now, I can understand where child support maybe there needs to be some adjustment there after 18, but I think just to blanketly change the age of majority to 18, I think all chancellors pretty much disagreed with that.
So I only say this because a bill came up, but Mississippi's the last state where everything is at 21. Really? So we're the last state to have that.
That sounds about right.
Well,
Mr. Chairman.
I understand. I understand, but I don't know. This may be speaking more as a parent than a judge, but I think there's a lot that children can be protected from. I'm up until the age of 21.
I mean, in that bill actually passed the Senate, didn't make it out of the House, but there was a lot of consensus and it's been filed by a number of folks. So, I mean, that we're not addressing that, but to that point, again, from a legislative standpoint, I go back to if 49 other states are doing it, why are we continuing to be the last one to do it? We may just take pride in it. I don't know.
Yeah. And I know that may be one of the topics that the task force takes up, and we probably should, since it's such an important topic, before we get there. I want to make sure we exhaust the child support aspect of it. Professor Kennedy or Professor Bell, have either of y'all put a lot of thought into whether Mississippi ought to take a look at a different method of calculating child support?
Oh, shit.
When Professor Kennedy or Professor Bell talk, I listen.
I've not really put a lot of thought into whether we should have a different method or not. I'm sure, just like Professor Bell, when you teach domestic relations, you teach the students about there are other models out there. So I was aware of the different models. I do think that one of the issues is that our parents, our non-custodial parents, pay until age 21. And a lot of them are surprised to learn that. So that might be a consideration to look at. I grew up in Texas. I haven't looked at the Texas statute in a while. I've been in Mississippi for a long time now, but they also use the same model that Mississippi uses, and one child was 25% in Texas when I was growing up. And we're at 14%. So I think there's a great disparity in what the different states may use as those percentage guidelines. So I think it might bear looking into what other states do. I agree with Judge Odom that Mississippi probably has the lowest income of any state, so perhaps the percentage is justified, but you seem to be getting a lot of interest in people raising that. So that seems like it should be a consideration.
And in Mississippi, chancellors still have the discretion of adding daycare or after-school care as an add-on, or to
And medical.
and health insurance and medical and other aspects of it that maybe weren't statutorily allowed in Texas. I don't know. So there, there still is freedom for the chancellors to add on to what appears to be a low child support obligation in the state of Mississippi. But it just may make more sense for legislators to look at a shared income model. I simply don't know enough about it, and I'm not getting the feeling that any of the other members of the task force have really delved into that topic enough to want to opine about it. If I'm wrong, let me know.
Yeah, I would add one thing. One of my biggest concerns about the child support system we have is actually the modification system. So I know that's not what we're talking about right now, but I'd like to flag that. I think it makes it difficult for parents to come back and get an increased modification. But there's this tension here. I think most child support awards are low for the child's needs, but then we've got this very low income group that if they're ordered to pay more than they can truly pay, they build arrearages that can never be forgiven and that follow them forever. So I don't, and maybe Michael, maybe you can address this. Is there a way to, if you use the income shares, to increase the percentages when you're looking at payors who really can afford to do that, but build in a protection that keeps somebody who is so low income from being saddled with $100,000 in permanent debt that will never go away?
That's a good issue.
Sorry. I think there's a couple ways to deal with that. One is setting up what's called a self-support reserve. And not to get too off topic, but there was some federal legislation that came down in 2016. It essentially mandates for what we call our quadrennial review. Every 4 years, we have to review our child support guidelines. And so this task force really dovetails into that perfectly. But one of the requirements for this quadrennial review is to set up a self-support reserve. This is how we do imputation of income. We have to take in the more fact-based. I think before, we would do blanket orders of minimum wage. We really need to look at what the education level is, what the economic, what the job market is around where the person lives. Like, can they actually get a high-paying job? And the third component is dealing with NCPs who are incarcerated. And that's probably the most controversial, I would think. I think it was a bill was submitted last year that almost went through, but an incredible amount of arrears accrue when someone's incarcerated. And what the agency's tried to do is submit legislation that would suspend that by operation of law. Some other states have done it. It's kind of innovative. But I think the agency also needs to do a better job of letting non-custodial parents know that they can request a modification of their child support case. Every 3 years, we automatically send out letters that say that, but I don't think we really do a great job of informing people as well as they could. And so I think that there's ways to do it, and I'd like to see this task force pick up some of those things, regardless of which model. If we move or stay in the same one, there's some things we can do to fix that, I think.
Anybody else?
Mr. Chairman, I know I'm not a member of the study committee, but I did want to add this. A couple years ago, Senator Wiggins, you may recall this, Senator Dennis DeBar had a hearing on the age majority question, and he had requested some research by Will Wilkins Group, the Law Research Institute. And I was there. In fact, it was in that room y'all are in right now when Will and an attorney that worked for him at the time made that presentation and compared our age of majority to other states. But there were so many exceptions to, if one state had 18, it would have exceptions that would trigger it to go to 21 or 19. And so if you would like, if Mr. Chairman, Chairman Odom, if you want, I'll see if Will can update that or at least send you what they compiled a few years ago. That may be helpful if y'all dive deeper into that discussion.
I think it would be helpful. Any type of information we could get our hands on, particularly of the type you're describing, I believe would be helpful. Thank you, Justice Pierce, for that suggestion.
Judge Odom, in my practice, I don't get a lot of pushback on either issue. I don't get pushback on the age of majority. There are a lot of exceptions in our statute right now. If you have a child that's 18, not in school, not pursuing continuing education, there's no child support would terminate at that point. Married, having a child. So there are lots of exceptions, which I think bring it back to 18, which makes sense. I'm not getting a lot of pushback on that. The one thing that doesn't make sense to me is I'm really proud that Mississippi is a state that saw fit to have college tuition and fees paid after 18, which most states don't seem to have. It does seem to me odd that it stops at 21 unless agreed to, which very few people finish college by 21. They need at least until 22. And a lot of people, 23 maybe, but it seems to me odd that child support, when you're paying for college, stops before a child actually can finish. But I just wanted the committee to know from my standpoint, I don't get pushback on the age majority or the statutory guidelines. I'm not hearing from your constituents, but I'm not getting that pushback.
And to be honest with you, nobody has ever come up to me in court and suggested that we go with a shared income model either. So I don't know if it's like Mr. Chin was saying, that's not exactly a hot topic that is raised, around the coffee pot at the county courthouses. But again, we don't have the perspective that y'all have with so many constituents.
Well, we may not need a recommendation then.
Yeah.
Senator Wiggins, what's the number you're hearing? If we've got 14% now, do people come back and say, and I was fascinated to hear Professor Kennedy say 25%. That knocked my ears back. That seems, I think people would stab somebody if they got 25% on them. But have you heard a certain number? I mean, Representative, do people say, we think it should be 18% or 20%?
18. Yeah. Because I mean,
this is new to me.
Mm-hmm. And I mean, I've heard an older lawyer told me one time, well, I had to pay 100% to take care of my children all these years. So, I mean,
and just thinking about what Professor Bell said, I don't know any numbers, but if you raise it up, then that may cut down on the times you come back for a modification, because people are like, I'm not getting enough, and so I want to come back and modify it.
well, were you talking about a modification upward or downward, Professor Bell?
Sorry, I was talking about upward modification. And I'll just go ahead and tell you this, that my objection is that I think in most states, if you get a child support award and the non-custodial parent's income goes up substantially, you can come back to court and just get the guidelines applied. And our standard is that the increase in the non-custodial parent's income alone is not sufficient for a modification. And that just makes no sense to me. If if the statute is presumptively correct, it seems like it should be presumptively correct at whatever point that person is paying support.
And that may be why we're seeing these bills, because just part of our job. Look, something happens, people get mad and they go to their legislator to file a bill. That's part of the process. So that may be they didn't get enough, or they were denied, or it didn't modify or whatever. And so there wasn't substantial changes or whatever.
No.
So that's why we're getting it.
So that would be,
I'm sorry, I should have added, that's not the case with DHS.
what do you, so DHS is, what do you mean? It's looking for downward modification?
No, I'm sorry. So Michael, is this correct? When DHS modifies every 3 years, you don't have to look at the child's needs. You just apply the statute.
That's correct.
There's language in the statute that allows DHS to look at that automatically.
And that may be the answer. It may be cutting down on the number of factors that a chancellor needs to look at to make a determination of whether a material and substantial change has occurred in the payor's income, not having to look at inflation or a child's needs or special needs of the parent, et cetera, et cetera. That may be an answer to cut back on what y'all are talking about and still.
That may be because we also get bills, I know, introduced in the House too, that go back and amend the statute with respect to those factors that you just mentioned. So that may be an option.
Good.
Can we make it consistent with what DHS, I mean, if DHS just gets to apply the guidelines, then can it just be consistent? I think that's what Professor Bell is saying.
It makes a lot more sense to me.
It sounds more equitable, because if you have an increase in the statutory percentage, you may have a cut down on the amount of modifications that are filed. But on the other hand, you're going to have an uptick in the amount of contempts that are filed for non-payment of that extra money, I would imagine. So it may make sense, just like DHS, to make it tied to the statute without having to come back and show material change. Just show that the income has changed.
Sounds like our secretary has our next recommendation.
The value dollar for dollar of a lawyer's services in a modification is impossible. It just doesn't add up to have to hire a lawyer to modify something like child support. I know the Supreme Court tried desperately to build escalation clauses into our agreements, and they became impossible to write. But I would love to see something simple like provision of an escalation clauses in these things, where percentage of income every year was evaluated and redone, because people cannot afford to do a modification. They can't afford to hire a lawyer to come in and get $200 more a month.
You don't get your attorney's fees automatically, even if you are able to prove a material change, unless you also go through McKee and prove inability to pay. So that's a good point.
Just that modification. Oh, just that modification can then be appealed, Judge.
Oh, yeah.
So I mean, that's a whole separate thing. Something, just listening to y'all and trying to take notes. This one's harder to take notes on. I'll just say that. But two things. One of the things I was looking at, I learned this morning and did not know, but just that Dean Bell talked about how we had different systems. We had sort of an income shares. I don't know if she would call it that, but from the 50s into the 80s, we had sort of an income shares where under Babel, Dean, it looks like they considered the both parents and how much money they contributed or could contribute. We changed that when we added the statutes in the 80s. And then quickly in 1 year had to change it down to 14% because I think there was a revolt when we put it at 17. But one of the things that I think while trying to meditate on Senator Wiggins talking about how we are an outlier in the United States, one of the things that in my studies does make us different is that we have chancery in the first place, which I quite like. Mississippi was unique. We followed the path of New York and Delaware and just a few other of the early states in saying we're going to have a separate court that's invested with equity. So one of the reasons I like being around Judge Schlegel and Judge Odom is because their brains work differently than mine, because they flex and they can create and bring different things to the table. I think that's a special thing in Chancery. So I really think we might be different because of that. That may be also a slight reason to defend it. But one of the things we've done is take away some of their ability to flex. And so in looking at the statutes now and really thinking about it and listening to y'all don't have the flex that you used to have when we put in that it's a rebuttable presumption of $10,000 to $100,000. It's hard to get around that it's 14%. If that number changed or went away, the chancellors have more power to decide with what's in front of them what the number is. Now, obviously, we put in the 14%, or the legislature decided we needed to have it because before that it was Wild West. And a lot of times you didn't have any equity. But there could be a way to think about it on the back end where the chancellors had more flex. That would also sort of incorporate some of Mark's ideas that they could build in different expectations.
But there's also something to be said about knowing what
Yeah.
the answer is going
It's
to
a
be.
huge
So
thing.
Mr. Chin can go, or Ms. Turner can go to her clients and say, this is what the statute is. This is what it's going to be. You don't have to worry about the peccadillos of what the chancellor is feeling that day.
I'm going to throw in what I call JCPenney logic. This is not very sophisticated, but I checked what the maker of my suit, and it's that fine French Clothier. And also I have a 2008 Honda Civic. So I'm not bragging about any of this. And the law clerks love to make fun of me for it. But one of the reasons I was curious about Judge Odom and Judge Schlogel's experiences and hearing from Mark is because it is not a Cadillac. I do not have a Cadillac. I'm not wearing a Burberry suit. But we have a slightly different system than the rest of the nation. And we also have people that struggle a lot financially. And so my Honda still runs. And the thing that concerned me when Michael started talking about shifting the cost to a system, what I started thinking about was, I really just now feel like I'm understanding some of this in the past hour. And I've been doing it for 17 years. And so I really start to see these systems. And so we would have costs of literal costs for DHS and implementing certain things. And then, of course, the costs of our trial judges having to implement the system, our lawyers having to scale to it. And that could be, while invisible, could be very, very high, even though it does make us an outlier, which kind of makes me concerned. I'm like, are we doing it wrong? But we do know how to do it. Like Judge Odom said, if I got a chart that says 14% one kid, 2 kids, 3 kid, 4 kid, 5 kid, you could tell somebody when they walked in the room. But again, that's JCPenney logic, and that may not be what the committee necessarily needs to hear.
In an effort to make best use of our time, it may be time to transition into what Judge Slogel and Professor Bell were talking about, and that was the age of emancipation, which also takes in, if I'm not mistaken, that Senate Bill 2220 regarding child support for adult disabled children. Jennifer, or excuse me, I apologize. Judge Slogel mentioned that you had a pretty good consensus from the chancellors that you talked with about keeping the age of emancipation where it is.
Right, and just, of course, recognizing all the exceptions we do already have.
Right. Right.
If I may, on that bill, because it's right here in our stuff, the optimum words are: the presumption of emancipation may be overcome by evidence that the adult child is incapable of self-support by reason of a physical or mental disability if the disability existed during the adult child's minority. Mm-hmm. So what was being presented and for this task force to look at is if you're if you're over 21, let me put it this way. There are people that say because they reach 21, even though they're special needs, they don't have to, the child support doesn't have to be paid. And what the bill was attempting to do was to require that to continue. That's the bottom line of it.
Yeah, my understanding of the law is once the child is emancipated or otherwise turns 21, the obligation to pay child support ceases. Correct. Unless there was a prior agreement made between the parties, like you saw in the Ravenstein case, which may be one of the few that actually extends the obligation of child support beyond 21 or emancipation otherwise.
I wrote that agreement.
Yeah, there you go. Well, no one appealed it, so it stuck. Good job. And the opinion was, it's not like it's owed to a disabled child over the age of 21. It was, if I'm not mistaken, Mr. Chin, no one appealed that parent's agreement to extend the child support beyond 21. Therefore, it wasn't up for modification later for termination.
As a lawyer with the facts of that case, I felt a tremendous responsibility to figure out a way to take care of that child. And I did a lot of work before I wrote that agreement, but there are many, many more children than we can imagine that need to be supported past 21. And there were some excellent dissenting opinions in the Supreme Court opinion on that issue. And I really think this is an easy one for us. I think this is an easy recommend that there needs to be support for children past 21 if they are not able to survive as adults. That's a no-brainer to me, along with all that needs to be done to take care of them.
Know if it's going to be that simple, though, reading some of the appellate court decisions, with the exception of Justice King's many dissents on this issue, the logic used was, would a child be required to support their disabled parent if the roles were reversed? And the consensus was generally no. How is that any different?
And let me add to that. I think I'm not familiar with that, but the reason, and look, Senator Parker was the one who brought this bill. The reason this bill in part was brought forward, because my understanding is part of those decisions. Because this was, usually you don't have something come forward to change the law to, I guess, that dramatically. And so that's why we wanted to look at it. So I think, without me knowing much, I think my understanding was, yes, there is that. It's not as quite as simple as you would think on the surface from a legal perspective.
It sounds simple, though. I know exactly where you're coming from, Mr. Chin. But do we know what other states are, like you mentioned before, Senator Wiggins, is Mississippi in the minority of states that don't require child support beyond emancipation for a disabled child?
We don't know, but we can certainly research.
I think that's correct.
That we're in the minority, Professor?
That's my understanding. I haven't done the research independently, but Justice King's concurring opinion in Ravenstein cites to a lot of other states. And my recollection is that he says that a majority of states, either by statute or by judicial decision, do provide a duty to support adult disabled children. There's also, to me, just a gross unfairness in our existing law. That I didn't discover this until I stumbled across the statute a couple of years ago. Men whose paternity is established through a DHS action have a duty, statutory duty, to support their adult disabled children. Other men don't have that duty, and no mothers have that duty, which just seems imbalanced. And I'm sure that was probably, that got into the statute as a result of some federal initiative, but seems to me if one set of parents has that duty, and then others should as well.
We're all learning something new here today.
But we could get that researched, and that, would that be something, Justice Pierce, that the Judicial College could get us?
Yeah, we'll get on that. Carol's excellent at research, and so we'll start that process. And I will also ask Will Wilkins if his group would be willing to update their research on the age of majority question.
Okay, thank you.
And I would like to add, I think custody and visitation would have to go along with that. I represent a man right now who can't see his totally disabled adult child because the lady won't let him. Now, he's not having to pay child support, but he would.
Yeah, I think that Senate bill introduced by Parker, it addresses making sure that there's some type of visitation.
It did. It stated that the court may make, modify, or leave in place previous orders regarding custody, visitation, or payment of expenses.
Right. That certainly sounds equitable. Anybody else that wants to chime in on that issue of child support beyond the age of emancipation for disabled children?
I have some insight that I would like to offer on that. More often than not, a 21-year-old child is going to already be receiving about $780 from the Social Security Administration with regard to his or her disability. So perhaps there should be some type of offset when it comes to calculating the amount the non-custodial parent would have to pay.
The other issue, Deandra, that comes up with that is that payment stops, the derivative payment stops at 18, but if our child support continues to 21, you have to then go back to court because nobody has ever agreed to set an amount after the child attains the age of 18. So I think that's something we have to look at too.
Yeah, it would stop at the age of 18. So they would have the option to continue the disability payments until they can go before a judge. But sometimes they just don't understand the process and will not continue the benefits. So there will be a gap between the age of 18 and 21 when they get before a judge. So I think the issue is broader than what we're discussing here. And there are some 21-year-olds that are, when it comes to discussing the disability of a child, I think we're considering children that may qualify for conservatorships, but there are 20-year-olds with ADHD, their own disability, ADD, minor, they're still disabled in the minds of the Social Security Administration, but they're not disabled to the point where they will require a conservatorship. Just something else to consider.
Yeah. I imagine how that is going to affect someone's ability to receive benefits from the state of Mississippi is something that's going to have to be discussed with the legislators if you do require support beyond the age of 21. How is that going to affect their ability to get benefits? I mean, I'm sure that is the issue that's raised whenever we discuss with people, or at least when I discuss with people, child support beyond the age of 21, because that's income for the child or the adult disabled child. So I'm glad we got the biggest minds on that. Anybody else on that issue? Okay, should we transition into the guardian ad litem fees? Since that was also in the Senate bill, do we need to take a break?
Judge, I told you you'd have it done today.
Yeah, well, you promised. Do we need a break?
Maybe a quick break, yeah.
Let's take a quick bathroom break and come back in about 5 minutes.
Is there coffee around here?
Judge Odom, can you hear me? Hey, it's Debbie. Okay. I wanted to let you know that I have to leave at 4:30.
Okay.
I'm so sorry. For
Well,
some reason,
we need to get all your brilliance out now then.
listen, some of these are such hard questions, and you particularly the child support. I don't know. And I looked at Michael had shared the Arkansas study with me, and it is so complicated looking at the economic models and trying to understand what's the best formula.
I try to get a consensus from the Chancery Court judges, but none of them have really studied this because all we're focused on is the Mississippi statute.
Yeah.
So, and I don't think any of the practitioners have as well, since they don't deal with it. So it may be better to go with a shared income model.
It's really hard to tell. It really is. The one thing I was thinking about though is, and maybe this is maybe not enough of a reason to do it. I do think it sends the message to the custodial parent that they have an obligation as well. And I think it makes the non-custodial parent feel better that it's shared, that everybody supports the child, because I think sometimes you hear custodial parents who seem to think child support's supposed to cover it all and that they're not supposed to contribute. And then you hear non-custodial parents thinking they're not contributing. So I think to some extent, the equity in it is how people feel about it.
Which is, 9/10 of what we see every day in child custody and divorce cases is the feeling, the emotion.
So I have one other issue I would love to put on the table, but I think I may be an outlier on this. I am not a fan of Mississippi's custody relocation rule. Do you ever hear that come up for discussion?
Being what?
That if a custodial parent decides to move, the fact that that child is going to be separated from the non-custodial parent is not in itself a material change in circumstances that triggers an Albright review.
Right. But I've never heard much of an issue from chancellors being able to find a material change in circumstances if they find that it is an issue.
Yeah. So it may be just me. I've just ended up in several cases or mediations where that was became such a difficult issue with whether the parents were going to agree to joint custody or sole custody, because their perception was that the other might move. And so it may just be my experience of those cases that I've run into.
Well, I have had cases where the custodial or the parent hadn't moved yet, but the rumors were out there that they were going to be joining a new spouse or a new partner in Birmingham or something like that. How that would alter, I mean, maybe you're right. Maybe, are you saying that we need to look at a unilateral rule that says it constitutes a material change in circumstances?
Yeah, that would be, to me, the more fair rule would be if a custodial parent decides to move, that triggers an analysis of whether a change in custody is in the child's best interest.
Right.
They shouldn't be allowed to move without coming back into court to have everything.
Yeah.
So what about our people at the Air Force and Army and Navy bases that are required to move under compulsion of law, Professor?
I think that makes a big difference. So the states that address it, they tend to put in factors like, what's the reason for the move? Is it a good faith move? Is there another alternative to the move? So I mean, I think the custodial parent still gets a preference because of continuity, but if they're just deciding to move and there's not a good reason for it, then sometimes it's a change in custody. But I know a lot of people disagree with that, with my position.
In Alabama, part of your divorce decree or your custodial decree judgment is going to recite that you have to give the NCP, I don't remember, it's 45 or 60 days notice of any intent to move with at the very least, the city, state, or country you're moving to. And that way the NCP can go back in and say, whoa, this is material. I can't see my baby anymore.
Yeah.
So, and just,
I think it's such a hard issue. I'm so glad you've got that experience in other states. It's really helpful to hear how that works in Alabama and other states.
it has made Mississippi look kind of like an outlier, as Judge Odom has been saying in many respects.
Yeah.
I love Colorado's, I think it's 78-day rule. If you don't have 78 overnights with your child, you pay more child support.
Yeah. Advantages of that income shares model.
Mm-hmm.
I might have mentioned this to somebody, but Wisconsin has an interesting model where their percentage of income up to 25%. And once the non-custodial parent has the child for more than 25%, it essentially switches over to an income shared model because it's a shared calculation. And so that might be something to look at. I haven't looked at that one in depth, but I've spoken to somebody from Wisconsin and they kind of mentioned that's how they work.
You know, I had a case one time, Mr. McCauley, where the guy played with the Miami Dolphins. And the judge used the $50,000 thing to keep him from having to pay the 14%, but instead ordered he set up some sort of annuity, which he never set up.
We get that.
The issues, there's little bitty intricate issues like that we probably need to at least toss around, but I think that takes us off our main purpose too.
But it's really not.
Well, I think I can look up, we might have a case like that. Let me write that down and I can send it to you. We have something very similar to that.
Yeah.
Okay.
Okay, yeah, I think we're on the same page. I get it. Okay, hey, can we get back at it so we can make the most of our time?
Do you have a dog, Professor?
You see me talking to my dog?
I did. I was like, it's either a dog or a cat, one of the two.
I'm trying to keep her from jumping in my lap. It's like, get away.
So one of the other matters that were contained in the Senate bill for the task force to look at, I'm going down the list, is the review the current trends in the imposition of cost and fees for guardian ad litems and related issues on guardians and make recommendations based on said review. I think it would be helpful for us to hear what y'all have been, that I'm addressing this to the legislators, what y'all have been hearing from your constituents to make this an issue for the bill, because I may not understand.
I'll start. And I apologize if it's a little disjointed, but not just this session, but over the years, we have received bills to change how guardian ad litems, one, are being paid, and two, how those are being handled. Some of that has come. I've had members come to me talking about how their constituents have had bad experiences with guardian ad litems, in particular, fees being way overcharged, not doing the work, that stuff. And also, I know in Harrison County, there's a lack of guardian ad litems, I think, and across the state, there's a lack of guardian ad litems. And when you talk to guardian ad litems, the amount of work that they have to do for what they're getting paid through the courts and things is a real problem, which then leads to less people being guardian ad litems and all that. And which I think it becomes a cycle. That's where I've heard on the Senate side on that.
And it's the same on the House, and particularly with constituents as well, is the fees that have to be paid for the guardian ad litem, and then also the number of guardian ad litems as well.
So it's, I guess, litigants who have been paying attorneys' fees, and then on top of that, the court assesses a guardian ad litem fee. And I know from experience that in some cases, guardian ad litem fees can go in excess of $10,000. And
I'm sorry, I didn't mean to interrupt. And let me say, it may be, because I've talked to various chancellors, it may be that this task force looks at considering it ought to be something that either the legislature or the counties put up money for and create a pool or something like that. I don't know, but I think that's all on the table.
I think this is a perfect opportunity to listen to the other members on the task force as to what their opinions on this are. And I'm going to be listening particularly to Mrs. DeFatta and Turner on this issue, as well as Judge Slogel. I mean, what do y'all think, right? Is it broke? Does it need to be fixed?
I definitely think at times that it is broken, in the sense that frequently the party who the guardian ad litem found against in their report tends to be the person or the party that is ordered to pay fees. And that's a problem. I definitely think the low fees or lack of payment tends to kind of water down or dummy down the quality of the guardian ad litems you get. You'll tend to find a lot of younger people doing it, and a lot of people who maybe don't have any other options for clients. They just want a case and have some income coming in. And personally, I find the better guardian ad litems have more years of experience. I charge a very low hourly rate as when I'm appointed a guardian ad litem, simply because I know everybody is paying their own attorney. They're typically limited funds. And so I think the idea of having some sort of a county fund or a government type fund is helpful. But I also think there are clearly cases where the people do have the money. And so in those instances, they should be required to pay. And it should be more of a follow through. A lot of times the case ends with the guardian ad litem getting an award, an order. Here's, for your fees, this person has to pay it. And there's no follow up unless the guardian ad litem has to file a contempt or a show cause why they haven't complied with the order. So you're kind of chasing your fees after you've, sometimes it's been a year and a half, 2 years or more investigating a case. You end up ruling against somebody, and now you have to follow that person around to try to get money from them.
I can tell you that Chancery judges often feel in a pinch because we're the ones appointing the guardian ad litems. We're the ones benefiting from the hard work that the guardian ad litems are doing. But at the same time, we can't prosecute their payment or non-payment. And it's kind of painful to have to watch guardian ad litems file contempt actions to be paid for the hard work and valuable work that they did. So I understand exactly where you're coming from, Ms. Turner, on that. Ms. Tafada, do you have any thoughts on it as well? If she's still with us. I think the child support discussion did her in.
Well, and keep in mind that the statute requires appointments too. I mean, they're not always discretionary.
I would like to add in the absence of Melissa, is that based on my experience when I was a chancellor, my problem wasn't the expensive bill. My problem was the fact that neither party could afford to pay the guardian ad litem. So I think if we need to be, y'all need to be careful. I have to be careful. I'm trying to be quiet, but y'all just need to be careful in assuming that the issue is these guardians ad litem are too expensive. I found the opposite side. I found that I couldn't get my guardians ad litem paid sufficiently, which comes back to the point that Senator Wiggins had mentioned. I know, for example, in Harrison County, Donna, I know that they had established a guardian ad litem position years ago that the county funded. Jackson County put some money in, but it wasn't enough to go around to fund the needed guardians ad litem in cases where people just didn't have resources.
I quit doing it probably 10 years ago because of two cases where I was in trial 3 days each case and got zip. Judge was going to order the county to pay and then decided he didn't have the ability to do so. So I quit.
The alternative that has been floated around, and you discussed it a little bit earlier, Senator and Representative, is some type of like public defender or a county funded or state funded guardian ad litem. I talked before this meeting with Chancellor Martin, who has, I believe, 5 counties in his Chancery Court district: Simpson, Lawrence, Smith, Covington being some of them. They have a shared agreement with those 5 counties to pay for one guardian ad litem. I don't know if that's sufficient for the amount of work that they have. I just don't have enough experience there. We don't have a court or a county funded guardian ad litem in Rankin County. We do it traditionally, where we appoint them in cases where we're required by statute to appoint them. We appoint them discretionarily in other cases where we feel that they would be beneficial, and we just have to assess it to the parties as best we can and hope they can pay it. Many of the guardian ad litems we have in Rankin County are excellent, and they know that it is a service upon the court what they do, and they charge $150 an hour or even $100 an hour, where normally they would charge $300 if they were representing a client in litigation. But once if Rankin County starts having the issues that we've seen in other counties, apparently where good people stop putting themselves up for guardian ad litem work, that's a problem.
I'll add that I think it's headed that way based on comments that I've received and have heard, that because people are, I talk to guardian ad litems and they're just, for the work that they do, for what they get paid, or they're choosing not to do it.
Right.
And my understanding is Harrison County may be facing a little bit of that. And so then that begs the question, what is the obligation of the state? And I'm not putting it on the state, but how do we get there to help that, I guess?
There is no question from a chancery judge's perspective that guardian ad litems 90% of the time add benefit to a case, whether in getting it resolved or getting the parties to the table to understand and get it resolved, or to provide that extra investigation and recommendation to the chancery judge so that he or she can make the best decision for the interest of the child as possible. There's no doubt that they serve the people of the state of Mississippi an important role.
But I think one of the biggest problems that we see from my end is the mandatory nature of appointing guardian ad litems. And the guardian ad litems do a very good job, do a very thorough job. And one of the biggest problems is when the guardian ad litem makes a recommendation and the chancellor does not follow that recommendation. The parties have a lot of information from the guardian ad litem, but not as much information from the chancellor as to why the chancellor did not follow the guardian ad litems. And so now you've almost got both sides have fuel to the fire about, which side or which decision the evidence supports. And the chancellor should be wrong because the chancellor appointed this guardian ad litem and doesn't seem to want to follow the recommendation of the guardian ad litem. And so I do believe that we have too many statutes that require a mandatory appointment of guardian ad litem when that should be something very discretionary with the chancellor. And it should be discretionary, it should be very focused. Because, I've read a 10-page guardian ad litem report before, and I can't imagine how much time it took to come up with that. And in a way, other people complain, at least in their legal briefs, that if the guardian ad litem is doing this much work and providing this information, why do we need the chancery judge?
Well, yeah, but they can stop short of a recommendation on the ultimate issue.
Yeah, but it's still pretty clear what their viewpoint is, because the ultimate issue and the ultimate decider is always going to be the chancellor, and the chancellor is the one that certainly we're going to look at in the standard of review. But I think the point is it's almost a perception issue, and the perception issue is that if we're going to require a guardian ad litem in every situation, in a way, we're taking away some of the discretion of the chancellor to make some of the calls that can be made early and somewhat easy, and don't need a guardian ad litem in all the issues that they're required. And in some cases that are difficult, an easy choice for the parties is get a guardian ad litem, and that's going to guide the chancellor. And you can almost, if you get some say-so in who the guardian ad litem is, you've kind of got an idea from history about what they're going to say, how they're going to go about their business, and lawyers can lawyer and try to have an impact on it. I just, from my standpoint, I see the value of guardian ad litems. I've always thought that it needs to be something in the chancellor's discretion, something very specific, and not a simple overall type. Yeah, take a look at this case and assess the parties and who would be the better parent. Well, that's the chancellor's job. And in a way, the essence of the guardian ad litem has taken over the role of the chancellor.
I'd like to jump in on that if I could. From my perspective, I would like to dovetail exactly on what you just said. The court rulings say the guardian ad litem must be appointed if there's an allegation of abuse. The statute says the chancellor must follow the recommendation of the guardian ad litem unless they have compelling reason not to, and they state what that is. So the court rules also say, decisions also say that the guardian ad litem is not supposed to testify as to hearsay. The guardian ad litem is not supposed to express an expert opinion. So the guardian ad litem does all this background work, and they make a recommendation that the court is supposed to follow. And then the guardian ad litem makes a recommendation that becomes the decision of the court instead of the judge that was elected by the people, based on things that I, as a lawyer, have not had an opportunity to fully investigate, cross-examine, and go after, so to speak, in court, unless I spend 3 days cross-examining a guardian ad litem. I think there needs to be a real serious look at when we employ a guardian ad litem. In principle, it sounds like a very noble concept that somebody's out there to protect the interest of the child. But if they're not supposed to talk about hearsay, they're not supposed to state an expert opinion, how can they make a ruling on custody? And why should I have to deal with a guardian ad litem's opinion, which is a lawyer, instead of the duly elected chancellor? And speaking of pay, a lot of the guardian ad litems go for a year or 2 years without getting an order for payment of their fees. I've had them say to me, what do you think about getting, my fees? I said, you must be paid. It's not right for you to work for free. But I would like to see a serious examination of employing the guardian ad litem so much, and I would rather see it left to the judge to decide when he or she would like to have that kind of assistance, and specifically what kind of assistance it is. Maybe a home study that the judge can't do and bring it in. But beyond that, all these interviewing all the witnesses and all the family members and all the stuff that they're asked to do just takes the place of the trial when it shouldn't.
We had a case a number of years ago where a child tried to become a party in their parents' litigation. And so we've almost pushed and said, no, children can't be a party in that litigation, even though the litigation affects the children's interest. And so we've kind of pushed to the side, well, is that the role of the guardian ad litem then? If you've appointed a guardian ad litem in the case, does the guardian ad litem, or should the guardian ad litem, because they're supposed to be the guardian ad litem for the children, should they be allowed to intervene and become a party in the case and have an opportunity to litigate the parent's divorce and child custody and child support?
Well, there are multiple roles that a guardian ad litem can take. If they're going to be serving as an attorney for a child, they certainly can't be serving as an investigator to report back to the court. So, yeah, I mean, you're talking about a situation where multiple guardian ad litems could be appointed on a case, compounding the issue. I seem to remember a very eloquent and well-written dissent, if I'm not mistaken. It could have been in McDonald by a certain Justice Pierce that talked about the importance of guardian ad litems in emergency type situations and dealing with the hearsay issue that is so evil. I don't know. That may be a separate issue from payment of guardian ad litems that we were, directed to talk about. But man, they do serve a valuable role as far as this court is concerned. And I like to have the discretion in most cases on whether I'm going to appoint one or not.
Judge Odom, one of the things in listening to this and going back to what the representative and the senator were telling us, a lot of what we've talked about today has been very illuminating for me, but has been changing structures, perhaps, or looking at changing structures. But for some of this in terms of the fees, my lawyer reptile brain kicks back in, especially when Mark started talking about hearsay, which is a common complaint I would have as a lawyer, that this guardian snuck in a bunch of garbage and it shouldn't have been heard and all this. But there is a solution. I'm not telling you to tell your constituents to go pound rocks, but the solution for a lot of the cost issues is sometimes you just have to appeal it. It is a decision by the chancellor. He or she has the discretion to split the fees, has the discretion to allow hearsay or cheat in some expert testimony. And you can always ask, and we are frequently asked at the Court of Appeals to review these decisions for an abuse of discretion. Of course, the result is often the chancellor has very wide ability to fashion relief as she sees fit. But that, to me, unlike some of the structural issues we've looked at today that might change the way the system works, those are issues that might be case specific, where somebody may have a grievance or have some sour grapes issues. Those are legitimate concerns, but I don't know if they're systemic that can be addressed and if you change a line or two. Because you do have redress in the court system. You can go to Justice Griffiths and say, I ought not have to pay this. Or one I think we had recently was the chancellor had deviated, and I think we reversed. The chancellor had substantially deviated from the guardian ad litem's recommendation, and the guardian ad litem was mandatorily required to be appointed because there was a credible allegation of abuse. And the Court of Appeals reversed it because the chancellor didn't give a reason for deviating from the guardian ad litem. So there are some safeguards in the system. Unfortunately, these are things that are, in my personal experience, really hard to explain to people who just see a $4,000 bill after they lost.
Yeah, we could have a separate task force just on guardian ad litems. I don't think Professor Kennedy would disagree on that. There are a lot of issues. Narrowing it down to simply the payment of it, which was outlined in the bill that formed this task force, I think it's going to come down to whether the legislature wants to put that task on the taxpayers of the state of Mississippi and have generalized guardian ad litems that are on salary through the state or county, or continue on how we are. I don't know what other options there are.
Judge, may I add in that no one has taken into consideration that sometimes the guardian ad litems go into very dangerous situations without any help. And that's what we signed up for when we did this, but we didn't sign it up to go into a high crime area where there are murders every day. And I think we need to take into consideration what the state or the counties can do to help protect or assist them, at least when they have to go into those areas.
I remember the Court of Appeals pointing out in an opinion very recently that involved Professor Kennedy and one of her law students having to actually step into a situation. I agree, that is an issue that I wish we had a solution for as well. Maybe that could be addressed if it was a county-wide or a state-funded position.
Or even a statute authorizing the sheriff or the police to accompany them, because their position, at least the last time I talked to them about it, was that's not our business. We're not getting involved.
Right. If the guardian ad litem comes to me and asks for a writ of assistance from the local law enforcement agency in order to go do a interview, I'm granting it. I can guarantee you that. No judge wants to put their guardian ad litems in a position where they are in physical or emotional danger. So I'm glad that was brought up as an issue. Ms. Turner, were you trying to say something?
I don't know if she knows.
Sorry, I had to unmute myself. Yeah, I mean, I think the payment issue and the quality issues and a lot of hearsay and a lot of make work, I think the appellate courts have done a really good job of instructing chancellors to tailor the order to what they want and what they need and what they expect of the guardian ad litem. And as long as the guardian ad litem follows the judge's order, typically, obviously, the trial will work better. The judge will get the information that he or she needs, and then it shouldn't be an issue of, well, this person told me that, this person told me that. It's go in, investigate, and report facts, as opposed to just, hearsay type issues. But once again, I think it kind of goes back to if there are funds and if the person's getting paid, you'll get a better quality guardian ad litem, and hopefully you'll cut out a lot of I'll call it the sub issues of that. So I do think this is a key issue to getting quality guardian ad litems and trying to ensure that they get paid. In a lot of times in like the CPS termination of parental rights cases, it's my understanding that our chancellors will actually require CPS to pay the guardian ad litem fees in those cases. But everything else is just pretty much left on the parties in whether or not you can actually collect the awards that you get. Well,
Putting the charge on CPS was an option. This is great.
I mean, that's what I thought was always done. I mean, that seems like that's what's always done in our jurisdiction. Not that we ordered it, but it just seems like it's automatically that's what they do. But there's complaints about that too. There's complaints that the guardian ad litem who's hired by CPS is biased. But we do, I want to say in Harrison County, I think we have the only public guardian, official public guardian in the state. JD Lee, and now she does a variety of things besides taking appointments from chancellors. She, as guardian ad litem, she is the public guardian for the county. So she represents indigent litigants that may be potentials for conservatorships, guardianships, who have no one else, who have no family members or anything like that. She represents those who are, being processed for mental commitment, that type thing. So she does a lot of things, but she is, when we appoint her as a guardian ad litem, she is probably one of the most thorough people that we have. But I mean, realistically, I wonder sometimes, and I do this sometimes, if there's abuse and neglect, yes, if I'm going to appoint a guardian, I have to appoint a guardian ad litem. The other choice I have, and I have done it, is just send it to youth court. Because I can't get it's too much on a private guardian ad litem or even our public guardian ad litem to assess that situation. So a lot of times, going back to what I think your original comment was, Mr. Chen, was that, or maybe Justice Griffiths, but instead of just, yes, the statute requires that, but I wonder, does it have to? Because if there is abuse and neglect, you can send it to youth court. You can, I mean, I've ordered CPS to open up protection cases, prevention cases, go out and investigate, let it be handled in youth court, and then come back to me if they don't find anything. Those are other options. I mean, maybe it isn't, maybe we don't need the requirement that a guardian ad litem be appointed because we have a whole nother system. I mean, we could have it appointed in our discretion.
Is there anybody else? All right. Well, we have taken a look at and discussed the topics that were specifically in the Senate bill forming the legislative task force. It's getting upon 4:40. And I know a lot of the people that have.
And I had a couple of topics that we didn't talk about.
I want to hear them, Justice.
Well, I think there are a lot of topics that we've covered the three that were in the bill. But there are other topics too that we do need to discuss at some point. One of which being, what is it, joint legal and physical custody, and how that's had an impact, and whether that's of any meaning, and how to enforce it. I think another bigger topic that I would like to discuss, not today, but at some point, is how our rules play into this, our court rules play into this. I've been a big proponent of either doing away with Rule 81 or amending Rule 81.
You get a lot of happy
lawyers. And I will share with the other members of the committee, there have been motions to the court to amend Rule 81 and really take part of Rule 81 and move it down to Rule 4 that the court did not approve. And while these recommendations are to the legislature, I believe these recommendations need to be fairly comprehensive in our review of the domestic relations. And quite frankly, the Conference of Chancery Judges was behind the review of Rule 81 and Rule 4. But we also, as part of this, we need to look at how this plays an impact in the rules of civil procedure that affects these cases. Because my big opposition to Rule 81 is that all these other states that we've done this study of, none of them have a Rule 81, and yet they're able to have a divorce practice without Rule 81, without having to serve process to a date certain, without the possibility of a void judgment and several things like that. And so if this committee is going to be comprehensive in looking at our domestic relations laws, I think we need to look at those rules, and we need to make as part of our recommendation, not only what we think the legislature needs to change, but what possibly the courts need to change about the procedural rules that have an impact.
I will note on line 67 and 68 in the legislation, it says, and to review any other matters related to domestic law, which is broad, but I think that covers maybe what you're talking about.
Could you elaborate on the custody issue, things you think are at issue?
Well, my elaboration on it is, I mean, we've got the statute that provides for joint legal and physical custody. And we see that oftentimes, and there's somewhat of a confusion, at least as how that's applied and how that's enforced. Now, we have a number, I think, fathers that have joint legal custody yet are not able to make or not involved in some of the medical decisions with their children. And I think, when we're looking at those statutes, what does it really mean to have joint legal custody, but not joint physical custody? I know what the statutes say, and I know how it operates. But it seems to me that that's part of the discussion also. Do we need to make any changes with that to require those to be enforced, or to change, wonder why they're not being enforced that way? And what's the remedy for? What's the remedy for a father who has joint legal custody but is not making decisions about the school of the child or the health of the child and some things like that? And we see a number of fights, usually over child support, that have to do with asking a non-custodial parent to pay for something the custodial parent wants done, whether it's travel, sports, or private school or college tuition and things like that, that there just seems to be no teeth in being a joint legal custodial parent. That you may have, and quite frankly, joint physical custody seems to have its problems too, especially as soon as the child gets up to school age. And I just think that needs to be part of the discussion. I'm not making a recommendation one way or the other. It's just areas that I see confusion, at least in the cases that come before us.
Just, I will note, thanks to Ethan, he pointed out that in section 1 of the bill, that it's to develop recommendations to the legislature and the Mississippi Supreme Court relative to revising Mississippi's domestic relations. So,
and that's where I think the statutes and the procedural rules both have to be addressed as part of this.
I sign on to any attempt to modify, amend, or otherwise rid us of Rule 81. I guess this would be a great time to poll the other members of the task force that are still with us about other matters related to the above issues or related to domestic law that you would like to see the task force take on. I appreciate Justice Griffiths giving his. Anyone else? Professor Bell, before she had to get off of our task force meeting, mentioned the issue of modification of custody automatically in the event one parent moves out of state. That was one of the issues that she had raised. Is there anybody else with an issue that they would like to raise on the task force?
Yes, Your Honor. I've been appointed chair of an ad hoc committee to get collaborative law going in Mississippi. We're working on that right now. And if this also includes recommendations to the Supreme Court, I would like to have the opportunity for this committee to discuss collaborative law and the benefits in family law and perhaps other areas of law.
If I'm not mistaken, collaborative law is a term of art. For those that are unfamiliar with it, you may have to Google that.
Very quickly, collaborative law means that the attorneys and the parties function as a team, and the attorneys sign an agreement to withdraw if the settlement discussions break down. So that provision serves as a glue to keep people at the settlement table. I'm told this works 90% of the time around the country in the 22 states or so that it's employing it. It takes the adversary nature out of the settlement discussions. It takes the attack mentality out of the discussions. One of the best metaphors I saw that was a presenter showed two lawyers shaking hands in the normal settlement discussion, shaking hands, but both of them were holding baseball bats behind their back. And that is how we negotiate. And so collaborative law is designed to take that out, which will require training and a change in mentality on the part of lawyers and litigants. But it is something that I would like the committee to look at, the task force.
Well, that'd be so helpful in family law.
Anybody else with a topic?
Mr. Chairman, the only thing that I would say is that since time moves so fast and we are at the end of August already, at some point, December 1st is going to sneak up on us. One thing I think might be a good idea for Senator Wiggins and Representative Cockerham is to consider at whatever's included in this committee's report to reenact and continue this group into next year for the 23 session as well, because there's so many topics that I think would benefit from this that we just won't have time to get to.
I concur.
If that's a recommendation, we certainly can do that. There's been task force that's been done. And to the point that if there needs to be a whole different task force or something to look at on GALs, that makes sense.
Yep.
What?
I love having broad discretionary powers.
Well, we were sort of discussing this earlier too. As far as this task force is concerned, what is the better approach to narrow it to where we come up with a few things and go with that? Or try to cover as much territory as possible if this is the only chance we're going to get?
Are you asking us?
Yes, I'm asking. I'm asking everybody really, what is the better approach?
Well, I'll answer this. Having particular recommendations, put it this way, the likelihood of us accomplishing all of what gets recommended in 2022 is probably, there's only so much you can do. To Justice Pierce's point, if you continue it, then it can be an ongoing thing and we can reconvene and do that. So considering time elements, let's just say we did the whole thing and there's 15 recommendations, the likelihood that being enacted in the legislature in 2022 is probably small. But if you have 2 or the 4 that we talked about, and I'm not pushing that, then that gives us as the chairs of the 2 Jud A committees, the ability to do that. And if we need to have the chairman come in and testify before the committee about this is what we discussed. But I think the point is it being very broad, it would make sense to continue it. But we can initially do another bill or whatever to say, let's continue this. I don't know I hope I answered your question.
You did sort of, but I would think we need to kind of rank what is important to us. And I don't like some of our earlier discussions, especially when it goes back to the ID divorce, we're talking about possibly amending more than one statute here, but I'm envisioning, well, one of our recommendations gets accepted, but not the others. And so then if they were interplaying, then that wouldn't be good. So we have to figure out, I think, what would, rank them in order of importance and just assume that probably not all of our recommendations are going to be followed
But that doesn't mean it won't get carried over to the next.
to the
year
next
either.
time.
That's right.
And I think it's helpful to have, like we identified from the outset, what 3 areas or 4 areas that we wanted to address. And then Justice Pierce came back and said, which I thought it's a very good idea, that we carry this task force over to 2023. But I think it's better for us to have maybe 3 or 4 solid, good recommendations on whatever issues or points that we want to tackle. And then, since we know that there are probably going to be some members of the task force who have some other areas that they want this task force to look at, if we can't get them all by December, then let it carry over into 2023. But to answer your question, I think Justice Griffiths alluded to this area when we were talking about the time frame. For instance, when we were looking, I think it was at the irreconcilable differences divorce, some areas, and maybe this is what you were alluding to, some areas that may be a little bit better in the recommendation to leave it broader, so that, for instance, in the Senate and the House, we may have to go to conference on one particular issue because maybe the Senate wants it 30 days. I'm just using this as an example. Maybe the House wants it to be 60 days or 180 days. And so I think in some of the recommendations, it may be better to leave it a little bit broader, just so that the House and Senate can decide what they want that particular number or what they want that language to look like.
So we're just providing more of a structure, is what you're saying.
Yes, in certain areas. I think it just kind of depends on the topic.
Could I make a suggestion then that, I know one of the issues was next meeting. And it seems to me that I think we need to have more than one meeting, but it seems to me that based on our discussion today, that maybe our next meeting needs to be focused on the child support calculation issue. And it seems that there was less disagreement about that. It's simply, we need to do some reading and have a discussion and come up with a recommendation. And I think, I'm not sure exactly what we need to do, how we come up with a report. All the reports I participated in, I've written. And so since I'm not the secretary, I don't want to write this one, but.
In this one, the Judicial College
Yeah,
is tasked with that.
it seems like that we need to come up with our ideas, our suggestions, our recommendations. And there needs to be a meeting where we talk about nothing but guardian ad litem and try to come up with something hard on that, maybe the second. And really the third one, and probably the more difficult one, may be to talk first about just kind of general domestic laws, and the first being no fault divorce versus easier, let's call it easier grounds for divorce, and kind of move through those and see if certainly by December the 1st, I think this task force can definitely have recommendations on those 3 areas. Now, the question is going to be, the harder question is going to be a little bit further going through more detailed domestic relations laws. But I would think that with the chair, we could schedule either Zoom meetings or in-person meetings and create a vehicle by which the Judicial College can start the drafting of a document, and we can start offering suggestions and changes and edits to it.
Sounds good.
I like that plan, Justice. I think.
That's why you're the chairman.
Wow. Thanks for the nomination. I think now would be a good time to go ahead and call it a day for this meeting. And I will get with the chairpersons of and the House and the Senate about setting another
Do you
time.
want to, let me say this, and by the way, there's a number of task force or other things going on. This room can be available and I think that's where we want to do the meeting like this. We just need to get it with Pat to get the date on there. And if that's if we want to do it like that.
I think so. I think what we're going to have to figure out the availability of our members and set it from there. But I do think, I agree with Justice Griffiths. We need to kind of narrow our focus, like Representative Cockerham said, on maybe 3 or 4 main topics, and let's get to work.
And thank y'all for your participation. It truly is beneficial, certainly to us as legislators to know that. Thank you very much.
I think I heard a motion to adjourn.
Yes, motion to adjourn.
Approved. Thank y'all for joining on Zoom.
No.